return Friday already. Callum, are we? We're being broadcast. So this morning, today's business is primarily to allow the objectors to cross-examine Mr. Colin Miller, whose recognition you've had. However, there's a couple of things first. First of all, my office has had an email from Ms. Macmillan to say that she's unwell today and can't attend. She's also been good enough to say that she wouldn't have had any questions from Mr. Miller anyway. I'm a bit disappointed that she's unable to attend, of course. I hope she's okay. But what I would say is, if there's anything that any of the other objectors wants to pick up from Ms. Macmillan's information and ask questions about, I wouldn't object to that. So if you have things you want to ask about.
I don't want to pry, but could the nature of her illness lead her to believe she has no questions when, in fact, on reflection, she might?
Well, that's a bit of a difficult question for me to answer.
If I may rephrase it.
Let me put it this way. I wouldn't have thought so. From what she said, I wouldn't have thought so.
In the event that she later discovers that or remembers that she does, would there be opportunity for her to pose them?
No, I'm afraid not. Not at this late stage in the inquiry. And Ms. Macmillan has made her position quite clear. I mean, I'm taking it a bit further than Ms. Macmillan has asked for by saying that if you want to ask, if you like, Macmillan questions, I wouldn't put up a fight about that. Okay? I think that's the best I can do in the circumstances. And of course, I'll be able to ask questions myself.
Would anybody have a copy of Ms. Macmillan's objections that we could refer to derive any questions that might?
Well, yes. It's in Ms. Macmillan's objection is in, well, the original objection doesn't give you very much information. I think the most substantial thing Ms. Macmillan's put in is her statement of case. And I'm afraid I don't have a copy I could give you, although it is on the DPA website. So that's the first thing. The second thing is, yesterday in a time-honoured fashion, we found out about potential additional documents at Mr. Ferguson's instance. And I have a copy of an email that Mr. Ferguson sent to yourself and to my office in the fastness of the night, but which only reached me this morning. And Mr. Ferguson is asking to include the 2025 version of the SHIP and also a document that he refers to as the minutes of the Special Council Booklet 1, Item 2, which on a superficial look seems to me to be the minute of the reports that went to the budget setting meeting. Have I far out on that?
No, I think you'd be correct about that. This was a budget setting paper in relation to the housing revenue account for capital and revenue budgets.
Yeah. Well, that's what it looked like to me. I mean, that's what it says it is. Now, Mr. Ferguson has clearly done his best to give it the title that seems to him to be apposite, but I don't think that's probably the official title.
This isn't officially known as the Affordable Housing Investment Programme, if that's what you mean.
The Special Council booklet item, the second item that Mr. Ferguson has tabled, if I can call it that. Is that the? It doesn't look like that to me.
It's not that. My understanding is that there isn't such a document as such. Rather, there are.
Can I circle back round to that? Whatever it is, and I'd like to know exactly what it is, Mr. Ferguson's document, the Special Council booklet, is very recent. It's February. It's a review of the situation in February of this year. And we have the older version of the SHIP, so his other document, the 2025 version, seems to me to be an update. I am inclined to the view that these updated documents should be considered by ministers. Do you object to these documents?
Ma'am, I think we've already submitted them as of yesterday to the DPA. I think those were amongst the updated SHIP. I believe was one of the documents that Miss Livingston sent to the DPA yesterday following our conversation on these matters.
All right. That has not come on to me. But so is that exactly the same as the document that Mr Ferguson has attached to his email of yesterday evening? Is it the same document?
I believe so, the first document.
So for that document, you're not objecting? Now, the other document, have you had a chance to look at it yourself, Ms Hamilton?
We've had a limited opportunity to do so, but we have done so, and we don't object to that document being received.
Yes. Well, I think, I think this has been a very tricky year, and I think in updating a case that was supposed to go to inquiry last year, I think a little bit of latitude in updating is okay. So, and I think ministers should have the most up-to-date position to consider. So, I'm going to allow these in. I think if Mr Ferguson, I think we should make them council documents rather than your documents, because the council will be in a position to give them a number and to handle them in a way that doesn't give technical difficulties. And they'll also be able to tell us exactly what the official title of the document that you're calling Special Council Booklet. But I don't think that can be what its official title is. It'll be report to the committee or something like that. So I think if we could make them council documents, they do create, accepting them creates a number of difficulties, because I think they should have been in before Mr Brodie gave his evidence, and they weren't. To patch that particular issue, what I'm going to do is I'm going to engage in a written submissions procedure in respect of these two anyway. Since I'm expecting the council to be fairly familiar with them, and Mr Ferguson's obviously been looking at them too, it would be a fairly short compass written submissions, and it would be an exchange, first submission and then second submission.
Ma'am, I think on that point, I understand your preference for simultaneous exchanges generally, but we've still to hear from Mr Ferguson what he's interested in within these documents or any part of them. So my strong preference would be to see that, and for the council to be given the opportunity to respond, because otherwise we're somewhat feeling in the dark with it. Well, and it's a question of notice as much as anything else.
I do see to make it intelligent, it would obviously be more expedient to see exactly what Mr Ferguson has to say about it. That's a fair point. So we'll do that sort of thing with it. I'll set the parameters for that in a minute. When we talked about this yesterday, you expressed concern about delay, but I don't think it need really delay. After all, written submissions will require to be done. I will be getting on with the report in the meantime. I don't envisage this causing any significant delay in the completion of my report.
I think similarly, ma'am, if we can see what it is that Mr Ferguson wishes to say about the documents, it may be that, for example, it's a relatively short response from the council, whereas without that knowledge, we may be producing a treatise on the whole thing, which is quite unnecessary.
You've absolutely persuaded me on that. That's fine. Now, the next mystery document that we have is something that Mr Ferguson's been calling the AHIP, which, as I understand it, Mr Ferguson, you're meaning the Affordable Housing Investment Plan. And you say in your email to my office that it's disappeared from the council website. Now, complex websites, can you shed any light on how you found it in the first place? Where did you find it in the first place? Where was it? Where did you get it?
Yes, ma'am. It was one of the many results returned as a query for a particular file type with a particular keyword. That in question was the AHIP that I was looking for, and there was a.
Did you search for for affordable housing investment plan?
Yes, ma'am. Having seen it referenced in the SHIP prior, and there was.
You saw a reference to a plan called the Affordable Housing Investment Plan?
Yeah, in the SHIP, and it appeared in another PDF file, which is where I was looking at the information in context. However, when I tried to find an updated version of it that was similar to that which I'd first seen, I was actually unable to locate it on the council's website. Oh,
right. Well, that's a slightly different thing. The document that you originally found is still there.
I couldn't actually locate that document, ma'am.
Right. But you're absolutely clear in your own mind that that was a document entitled the Affordable Housing Investment Plan?
Certainly, or in reference to it, yeah.
But when you're, or in reference to it, you see, that's the thing. We know, even I know how search engines, you could have got, if you put the phrase Affordable Housing Investment Plan in, you could have got quite a lot of returns that needn't necessarily have meant that one of these was a document called the Affordable Housing Investment Plan. Right, Ms Hamilton, and I'm quite happy to hear from Mr Brodie on this too. First of all, is there such a council document as the Affordable Housing Investment Plan?
My understanding is not. I think it probably will be quicker to let Mr Brodie explain the position to you.
That's fine.
Certainly, yeah. The AHIP actually stands for the Affordable Housing Investment Programme. So it isn't actually a document as such. I'm not aware of a specific document which references the ins and outs of that, but the details of that are actually contained within the document that Mr Ferguson has asked to be submitted to the inquiry. Both actually, yeah. So between them both, one sets out what the programme is essentially, and the other one sets out how that's budgeted for. And they're both referenced within that special council paper that's been submitted. So all of the information I feel is probably within that document that's relevant to the questions that Mr Ferguson probably has, without knowing what they exactly are.
Right. I think I'm reasonably comfortable with that explanation. It makes sense to me from knowledge of how councils work, kind of thing. But do you have any comments or concerns you'd like to express?
No, ma'am. I think what Mr Brodie's just said is accurate and makes sense.
And do you appreciate what I'm suggesting here? What I'm suggesting is a short exchange, a short time scale of written submissions. Ms Hamilton has, for very good, very sensible reasons, asked that you go first, and that is actually fair enough. I'm just trying to compress everything by going for simultaneous exchange. Whereas, as Ms Hamilton has said, it depends what you say, and it will help them to answer in a concise and focused way what you say. So it is sensible to see what you have to say first. So the Council is going to absorb these documents into their productions. We will publish them. They seem to be, there's nothing controversial about publishing them. Can you give me a bit of a handle on how long it's going to take you to prepare your written submissions on these? How long do you think it'll take you? I'm going to be quite...
Yeah, I'd expect no longer than my closing submissions, ma'am, so really no more than a week.
Well, I mean, that's what I'm worried about, is the fact that you've got these two, potentially quite substantial pieces of work to do, and I don't want you to have to be trying to do them both at the same time, although that may be quite sensible. Could you do your written submissions on these pieces within a week? Would you be able to do that?
Yes, certainly, ma'am.
And might you even be able to do it more quickly?
I'll try and produce it as expediently as possible.
Because that really would be helpful. If you could do that, it would just keep things rolling along, if nothing else. It would let you turn to your written submissions proper, for which I would extend a bit longer time. Well, that seems quite encouraging, Ms Hamilton. So we'll work with these new documents. We'll move on from these new documents. It's less chaotic than it could have been. I don't know to what extent you want to ask questions about them when you've got Mr Miller as a witness, and we'll see. In the roof. But if you want to ask questions of Mr Miller about the content of these documents, you will be presenting me with difficulties because I haven't seen them. I can't see them until I know that they've been accepted by both parties. So I might have to rule such questions out of order or at least ask you to move them to your written submissions. See?
Ma'am, I did take the opportunity to ask Mr Miller this morning if these were likely to be matters which he could comment upon, particularly if it's around the question of housing need and demand, and it's not his area. Yeah. No, from Mr Miller's recognition, that's what I understood to be the case anyway. So, right. I think that's that all tidied away reasonably. Okay. So, Mr Miller, the way in which we've been doing this is a bit unlike normal, usual public inquiries where you get a chance to read your recognition out. We're not doing that. We're taking your recognition as read, and the objectors will ask you questions. And then after they've finished, I will probably have questions, and then Ms Hamilton will re-examine you. So it's a bit unusual, probably the way we'll be doing it in the future, actually. So, Mrs Ferguson, do you have questions of Mr Miller?
Yes, ma'am, thank you. Hello, Mr Miller. I'm Julie Ferguson. I live in Block 2 on the top floor flat in Block 2, and I've been there since 2013. So my questions will only relate to you in that time period because I can't comment on what's happened before that. Now, I have this document here, EDC 65. And my understanding is this is a list of repairs that were carried out to the block, and there's an amount which I'm assuming are the costings in row C, and I'm assuming that row D is when it was suggested it happened or it was requested, and row E is when the works were carried out. There's a number of things from 2013 that, to my knowledge, never actually happened. One of the main ones is the painting of the close at a cost of £4,872. That happened in March. I moved in the August, and the close had certainly not been recently painted anywhere, because that was one of the factors when I moved in that I thought, oh, there has to be something done about this because it's very poor. And there's another one for painting.
Well, can we maybe, it's always a bad idea to just lump too much into the one question, Mrs Ferguson. Mr Miller, can you comment on Mrs Ferguson's position, which is that the close painting in 2013 didn't in fact take place?
Yes, ma'am. Good morning, Mrs Ferguson. The painting for this particular area, when the 3 blocks were in existence and Block 1 hadn't been demolished, work was passed to the Council's in-house DLO, in-house contractor, property maintenance services, and their painting squad were out, and their instructions were to undertake the close painting to the specification provided by the client side in those 3 blocks. And I happened to be on site when work was being undertaken. Now, I was on site at Dryborough Road, Block 3, only about 10 days ago. I was unable to gain access to the close, although I could hear people in televisions on, but I couldn't gain access in the service button. It was past the service time period. But what I could see was that the close had been painted previously, and the reason I know that is that the colour scheme that is there at present. And I would find it very strange were the in-house contractor not to comply with the instructions of the client at that time. I would have expected your close to have been painted at the same time.
So you didn't look inside what we're calling Block 2. You didn't look inside Mrs. Ferguson's building?
No, I didn't, ma'am.
But you kicked in the door, in the closed door of Triborough?
At Dryborough.
So you know that Triborough was painted, is what you're saying. But you aren't in a position, but you can't verify whether or not the close painting took place in 2013 from your own experience.
That's correct. However, what I would also add to assist the process is that I've looked through the photographs that have been submitted, and in the photographs it's quite clear that there are the council specification of colour from the colour palette is there.
Yes, but in my block there was no painting carried out. When I spoke to my neighbours who'd been there for a very long time, they said that the close had not been painted in many, many years, in fact a couple of decades, and they had to arrange completion of painting that had been carried out back in the day. So I just find this list of repairs confusing. I wasn't aware it was for every block, the 3 blocks, and that would maybe explain, to my mind, the expensive costings. But the specific ones for 30 to 50 Nithsdale Crescent, the cellar door.
Mrs. Ferguson, you see how there's numbers
Yes.
in the spreadsheet?
Right.
And my version of it is really small, no matter what I do. Could you perhaps give me the number of the line?
175.
So 175. So that's the cellar door.
Yes.
Painter to follow once fitted. And if we read along the line, that's in 2014. So
yes.
What do you say is the position from your
knowledge? That didn't occur. The cellar door, since the time I've been there, has never been repainted.
So the cellar door's never been repainted?
No.
But, Mr. Miller, are we looking at the orders or the amount paid out here? We're looking at the budgeted figure, or are we looking at the amount paid out?
Budgeted figure. And the amount that was paid following that issue of work. These are extracts from the in-house contractor's what's called servitor system, and these sums are the price of whatever repair it happens to be, together with when the order was raised and the completion.
It's the date of completion.
Yeah.
So if it's like, is it kind of purchase order system? So
yeah,
you know what it's going to cost, and then
yeah.
once you've got completion, you authorise payment
yeah,
of purchase order.
That's correct. It goes through this system known as servitor. Now, in my precognition, if I'm correct, I listed in 2.5 through 2.51 to 2.58 how repairs are, how they come about once they've gone through the contact centre. Now, irrespective of whether work is undertaken as capital investment or a housing revenue responsive repair, if you're using the in-house contracting service, all the work goes through a job ticket. That job ticket will give a description of the work that's been asked for by the client, the housing service. It will describe that, and on completion of a job, the job ticket should show the amount committed and the final account, the final sum, because you'll appreciate when you undertake certain works, you might find something when you're there that needs to be done. So you'll have a basic commitment which will come from the council's, the in-house contractor's schedule of rates. You will have the final sum charged back to the client. You'll have the date when the job ticket's raised. you will have the date when the job has been completed, and at that point, if there's any subcontractors, that account can't move anywhere until their accounts come in. And at that stage, the yellow copy and the green copy are matched together, and the job will then be fed into the servitor system, and that's when the internal transaction takes place electronically.
Okay,
And
so you're talking about the paperwork, I think, there, Mr. Miller, aren't you? Yeah. Does anyone nip out and see that the job's been done?
when the work is completed, there's a 10% random inspection of work, which should be undertaken by the repairs officer. And it's simply a case, there's so many jobs that it wouldn't be practical to expect every single job to be inspected with the resources available, staff-wise. So I've actually mentioned that in 2.58 in my recognition as well.
Right, so that's what that means. Okay, well, thanks for that. Thanks for bringing in the colour that's in your recognition. Mrs. Ferguson, if I have you correctly, on that particular job, what you're saying is, to your knowledge, the job was never completed.
Yes, the close in my block has never had any painter work carried out on it in the 8 years that I've been there. And
well, you were talking about the cellar door.
What happened with the cellar door was the lock was broken and it had been phoned in to be repaired, but instead of repairing the cellar door, they had come and locked the doors to access the bins. At the front of the building, there's 2 white metal doors of louver doors. These were locked and none of us had keys to open it. When I phoned the girl, she said, no, the cellar door got fixed. I said, no, it wasn't the cellar door. But this went on for a number of weeks, to the result that rubbish piled outside of the doors. And in the evenings, foxes would come, scatter the rubbish, and we had to go down in the mornings and clear this. And it was disgusting. I myself phoned a number of times, almost daily, to explain the situation, as I know my neighbours were doing as well. But we were just told, no, it was the cellar door that got fixed.
That's her account of the situation. Are you in a position to say that she's incorrect?
No, I'm not in a position, ma'am, to say that she's incorrect, nor can I say it's correct either. This is something which has gone through the contact centre. I'm not involved in every day-to-day routine repairs. It's investment and involved
you don't have any knowledge of this repair,
no.
And you're not
No.
able to rebut Mrs.
No.
Ferguson's.
No.
And the other thing Mrs. Ferguson is saying is that she phoned a lot of times. Who did you phone, Mrs. Ferguson?
I phoned the council number, the direct number to go through EDC. I've got it on my phone here.
On speed dial?
No, no, I kind of gave up the ghost by 2015. No. What's the point?
But you called them the EDC general number?
Yes, and then you get put through to who you want to speak to from there.
Yes. Can you tell me who you ask for? Do you always ask for the same person?
I asked for housing. I explained who I was, and they put me through. Often, more often than not, it's an answer phone, and you leave a message. I did at some point have a direct number for Brian Walker, one of the housing officers, and I did have discussion with him in a number of situations.
Now, I sort of diverted you back to the cellar door, but can we stick with the painting? Mrs. Ferguson, I just want to be absolutely clear about where your respective knowledge. Mr. Miller, when the close painting that you went out to check recently that happened in and around 2014, can you tell me from this spreadsheet when that repainting, from your point of view, is likely to have taken place? Mrs Ferguson, could you give me the line number for the close painting?
The line number is 150 for
150.
the first one. And
Carry out internal painter work to closes at block, and that's the £4,872. So, Mr Miller, that's the particular work that we're concerned with. Can you tell me approximately when that work, from this information you're seeing, is likely to have taken place? Remembering it was 3 blocks, as I understand the position.
From the information I have in front of me, ma'am, it would be some point in and around the summer of 2011.
sorry, what was
Right. Now, Mrs Ferguson, if I can just bring you back onto the painting. As you've reminded us, you moved in 2013. So, you know, that's a couple of years. Is it possible that the painting took place and you didn't see it because you weren't there?
If it happened in 2011 and not 2013, then I wouldn't have been aware of that. But I did speak to neighbours within the building who told me that no painting had happened for a great number of years. And if Miss McMillan was here, she would be able to speak to that, because she was involved in finishing off the painting that was started on the floor when she stayed there.
Okay, so that's us had a bit of a handle on one large repair from your point of view, and then we've looked at another repair which you've got more immediate knowledge. What's your next question, Mrs Ferguson?
I wasn't aware this was for all 3 blocks. I thought this was relating to my block only. But also in the precognition, the reactive maintenance, and you've explained that, you know, you call the contact centre and then it gets processed. I have called...
Sorry, Ms Hamilton, what were you saying?
Correct, but perhaps that could be put specifically to, rather than for me to say.
So it's not. So you're saying that it's right? Okay. Ms Hamilton is concerned in case we're about to be under a misapprehension. The spreadsheets, if we look at them, we can see that some of the repairs here are attributed to a particular block. So presumably that repair is for that particular block.
What I take from this spreadsheet is that the £4,872.89 would be for this particular block. If it were to be for the 3, I would have expected to see that reading something along the lines of painter work to closes at blocks 19 to 39 Dryborough and the Nithsdale addresses. That's what I would expect to see. And what I'm looking at just now, Ms Ferguson, just refers to a singular block. When we asked for a print of works that had been undertaken at Block 2, and we made it clear it was Block 2, then this is what we received from property. Now, were it to be for the 3 blocks, I would have expected further sheet. So I think it's fair on my behalf to assume what I'm looking at is a cost for your block, or the block that you reside in.
Because that's the information you asked for. Right. You see, when you had a look to verify it and you couldn't get into the block 2 that we're talking about, 30 to 50, you went to Dryborough.
It was Dryborough, ma'am.
Yeah, I appreciate that, but when you went to verify it, you went to Dryborough. So, and if this, are you saying to me that this particular printout shouldn't include Dryborough because that's not what you asked for? Right. So,
what we asked for was a print of repairs which had been undertaken at Block 2. And I would not expect to have received anything for Dryborough Block 3, because I never asked for it.
So, in order to verify it, you had a look in Dryborough because you assumed that Dryborough would have been done at the same time.
Indeed, but I also went out to Dryborough knowing that that's the block that had previously been roofed, and what I wanted to see was just the kind of general condition, how it was, how it's been looked after.
Yeah, but I'm still trying to get a handle on what I can verifiably understand from this printout. Mrs. Ferguson, do you get what Mr. Miller was saying here? He asked for information about your block. This is what he was sent. So he's saying, so far as he's aware, this relates only to your block because that's what he asked for.
So, well, none of the paintwork has occurred.
Right. Could you tell me what hasn't occurred then?
Well, number 150.
150, carry out internal paperwork to close the block. Now remember, that's the one that Mr. Miller says probably occurred before you came into the block.
There was no evidence of it being decorated. I would have said, even in the last 5 years, the paintwork is quite disgraceful. You'll see it on the site visit. It's not good.
Yeah, but we are talking about 2013.
Yes,
so, you know,
and it's remained the same.
If I'm looking at paintwork now, it's difficult for me to take a view on what it would have been like in 2013. So I'm quite happy to listen to your description of what you... I mean, did the close, when you first got the house and moved in, did the close seem freshly painted to you?
Not at all, no.
Right, now, next thing, next repair.
The painter work, number 160, to the closes at the block.
So that's £309. Carry out internal painter work to closes at block, £309. And that's, again, in the window between 2011 and 2013. What do you say about it, Mrs. Ferguson, for Mr. Miller's comment? What are you saying about that, about 160?
Freshly painted anything within the close, internally, or to my knowledge, externally, to the block 30 to 50 that I'm in, since I've been there.
Are you in a position to rebut that statement then, Mrs. Ferguson?
No, ma'am.
No. Right, next point, Mrs. Ferguson.
I can't say it about the rubbish chutes. What's this? Door entry system. We did mention that 175, the cellar door, painted to be painted.
175. And I think we've got that story. And again, Mr. Miller said he's not in a position to rebut what you've said. And
the 46 Nithsdale, there's no date for these, that numbers 185 and 186.
185 and 186.
There's no date in column E. Does that mean that the works weren't completed?
That's certainly the way it's presented to myself would suggest the ticket was still open for some reason. But what I would also
it's not been done.
What I would also add is I'm not in a position to say that is the case, because, as I said, I don't deal with the repairs each day. I don't deal with responsive repairs.
But what you're saying is, it looks like the ticket.
It looks like the ticket would have still been
open.
live and open.
So it has not been processed as a completed repair.
Yeah. But it may well have been that when the inspection took place, further instructions were required. But whether the further instructions were actually issued, I couldn't comment, Mrs. Ferguson, because it wasn't myself dealing with that type of thing.
Just going back to, reporting of reactive issues for maintenance, I have over the years called countless times, and my neighbours, I know, have called countless times regarding things such as the door being broken, the lighting within the close being an issue, and for my own property and issues relating to me, when I contacted my housing insurance about the water coming in my house, I was told to contact the council. When I contacted the council, I was told it was condensation by the girl on the phone. I said, I'm afraid it's not, it's water ingress. And she stated the Master of Works would come and take scrapings from it. So that was sort of autumn time 2013, after I'd moved in, and for about the next, I'd say, couple of years anyway, I called on a number of occasions. I left messages with the Master of Works. No one has ever came to me. No one's got back to me. I brought it up with the housing officer, Mr. Walker. Nothing was ever done, and I see this down here in black and white, and it has never been the case for me that this is what's happened.
Mr. Miller, let me assist Mrs. Ferguson here. I assume that when the council is made aware that there is mould in a council building, they may pertain to the parts of the building for which the council at least shares responsibility. The council would take action, because dampness in a home is always a serious matter. Is that fair to say?
That is fair to say, ma'am.
Well, why is it the case that Mrs. Ferguson has reported mould and therefore potential damage, and on her account has not had a response? Why might that be in your view?
That is something, ma'am, which I could not address here today. What I would say to Mrs. Ferguson is, if you're making that volume of calls and contact and speaking to people like Brian Walker and getting no action, that is not the type of service which should be getting delivered to our customers, whether they be homeowners or whether they be tenants. And I can only apologise that you've found that experience.
I had a couple of calls, one to when I reported no lights in the close, and it was in the night in the winter, and I was told to get one of my neighbours, who was a local authority tenant, to make the call because she couldn't take the report from me because I was a homeowner. She wouldn't give me her name. I did speak to Brian Walker about the incident the following day, and she told me it would be 3 weeks before the lights were replaced because it wasn't an emergency. I stated that it was an emergency, it was wet, the stairs were slippy, and it wasn't until I spoke to Brian Walker the next day and the lights were replaced that afternoon, which was very prompt. But this has been a theme for me throughout my 8 years in Nithsdale. I just feel there's a general, it's Nithsdale, it's the Crescent, it's the blocks. And I feel that's just a general sort of reaction whenever I've phoned, and it's all right, yeah, we'll get that sorted, then nothing happens. Also with the stairs, when they're wet and slippy, both my children have injured themselves on the stairs. My mother has fallen on the stairs as well when they've been wet. And whenever I've reported this, it's, yes, someone will come out, we'll look at some anti-slip treading, nothing has happened. It is like the forgotten land out there, and how I was made to feel living there the last 8 years.
Can I just ask you, the accidents on the stairs, the falls, Mrs. Armstrong's and the falls, can you give me a date when these falls took place? What year did these accidents happen?
It was a while ago, wasn't it? And you fell first, then after fell, then my mum. Is it 2015? Or thereabouts? Afton was after you. We're thinking about 2015. Afton, it was about, a year later. And my mum, when she was up, she was having treatment, so that would have been, was it 3 years ago? 2 years ago, maybe 3 years ago for my mum.
So before the pandemic?
So,
before the pandemic?
Yes.
Yeah, so sort of 2018 time, might that be around?
My mum didn't want me to phone anyone or anything. She was, I'd say, embarrassed about it. She felt she'd just, it was slippy and she wasn't holding on to the rail properly, and she went down.
But you did phone about the slippy stairs yourself?
Yes, twice.
Twice. And when did you make these calls?
It was directly after it happened, because they happened one in the evening and one late afternoon, so it was the next day after you'd fallen that I'd phoned, but I can't remember the specific dates.
Right. I'm going to convert that into a question for you, Mr. Miller. I mean, as I'm sure you're aware, Mrs. Ferguson, but these reports obviously to the common part. Least, is there a special route for those, or do they just go into the system?
No, they simply go into the system, and I would expect, and I think it's reasonable to expect, if someone reports an issue to the council through the contact centre, that there's a trace whereby you will be able to prove that the call was taken and actually put through to the appropriate person for action
inside the
to
council?
be considered. Yes. I would expect that to be deemed as the minimum reasonable.
But would it be the case that in normal circumstances slippy stairs would be regarded as a repair that was more urgent than others?
I believe that would be the case, and I think one of the particular items that you would have to investigate is, if the stairs are wet, where is the water coming from? Is it a case of in a block of flats when you go into a landing? Windows have been left open for the driving rain to come in and rest itself on the landings. That would create a slippy situation.
So that's the kind of thing that would happen, but that has not been Mrs. Ferguson's experience, by her account, in both 2015 and 2016. Can you shed any light on that?
I'm unable to shed any light on that, ma'am.
Okay, Mrs. Ferguson, anything else on the spreadsheet that you want to ask about? You're finished with the spreadsheet. Right. Any further questions for Mr. Miller?
There's 2.10 that you'd been advised that at 2.10.2 there was no decision to reduce or alter the maintenance regime as a result of the decision to redevelop. I spoke to a council officer, I think it was late last year, who said that is what was happening. They were not carrying out any further repairs or anything to the block because it was to be demolished. And that was when I'd called about my neighbour who'd recently left the property next door. there was an alarm going off in our house, and I didn't know if it was a fire alarm or a smoke alarm or a carbon monoxide alarm. And also the lights were out in the close, and I said to the officer, well, can I just go and get some bulbs and put them in then? I think, I'm not sure, but I think we were between lockdowns. We had that sort of wee episode last year, was it before Christmas? And I'm sure my neighbour moved out in that slot, and that's when I phoned him, but I can't remember the exact date. But he did state that there was to be nothing done on the block because it was to be demolished.
Certainly, when I was preparing my precognition, I took the opportunity to speak with the Executive Officer for Housing, Grant McIntosh. Grant, in turn, contacted by email relevant officers such as Brian Walker, the team leaders, and they all form a part of the Housing Service Management team. And I was advised that at no time has a decision ever been taken to reduce the level of responsive repair activity at your particular block at Block 2. And I would be somewhat surprised were that to be a case where such a decision would be made that they would reduce it, because at the end of the day, the housing service, as a part of this local authority, Eastern Bartonshire, have a duty to their tenants in the blocks. Now, I do know, and I don't know if this will be helpful, ma'am, but I'm trying to do what I can to help. I do know that when the COVID-19 pandemic struck, that there was a great deal of difficulty in terms of being able to undertake specific works, because the operatives from our in-house contractor, at that time, they weren't allowed to gain access into property. Now, we are some, 18 months or something down the line of this pandemic, and I can only make an assumption that if there's been a reduction in repairs, it's been because of the pandemic and the instruction not to enter homes at that time when it was at its peak. But as I said a minute or two ago, I would be very surprised if a decision was ever issued to deliberately run down the responsive repair regime for Block 2, simply because the service and the authority have an obligation and a duty of care to the people living in that block.
The care with which you're dealing with this, Mr. Miller, I mean, you obviously spoke to the senior officers in charge of the housing maintenance service and got their assurances, but Mrs. Ferguson was in trouble. She was phoning up because she'd no light in the close, and somebody on the phone to her from the housing service said, we're not repairing that block because it's going to be demolished. Can you explain that? Because there is a difference.
I'm unable to explain that, ma'am.
Right. Mrs. Ferguson?
I think that's me, ma'am. Thank you. Thank you, Mr. Miller.
Thank you.
Right. Okay, Mr. Andrew Ferguson.
Thank you, ma'am. Good morning, Mr. Miller. Thanks for taking the time to answer some of our questions today. Just a quick point before we start, because it is important, just for understanding. I think on the front page of your precognition, it states that you're a development officer. However, in paragraph 1.1, it states that you're a development advisor, and in brackets, council stock. Would you be able to tell me what it is you do precisely at the council?
Yes. It's my job to work in the investment team and to effectively deliver contracts on site when they're identified within the Council's investment programme. For example, a window replacement programme, an MR render programme, and that will involve being involved with the procurement team, beginning to get to a stage where you are specifying what is required of the contractor and preparing several documents for use by our in-house procurement team before stuff goes to tender.
Thank you. So just to clarify, from the plan, would that be safe to say that that might be the strategic housing investment plan? Would that be that plan, or?
No, that's the capital investment programme, which is effectively all of our planned works with the information having been derived from the Housing Stock Condition Survey.
Thank you. So just in that same paragraph, it states that you've been employed in this field of activity since the 13th of October 1972. Is that broadly correct? Yeah.
Absolutely.
Yeah. So, yeah, and that's in service with various authorities, Glasgow Corporation. I believe is that Glasgow City Council now. So, yeah, it's almost 50 years of experience. That's indisputable. But it does state that you have no formal building qualifications. Would I just be able to ask, do you have any relevant qualifications as they relate to the delivery of the capital investment programme?
No, it's all experience through from 1972.
Okay. So just moving on then to paragraph 1.2, it states, I have been involved with this case since 2nd of March 2020. In the original list of witnesses submitted by the council, I believe prior to that which has been submitted now to the DPA, there have been a number of alterations, including individuals who were removed from that and replaced with individuals who we've had the chance to speak to already. But you were on that original list, and it stated that you were able to speak to you have a long history with the block, and you'll be able to speak to the condition and the repairs within it. I'm just trying to reconcile here the fact that it says you've been involved with the case since 2nd of March 2020. However, it states in the original witness list submission that you have a long history with the block. Can you clarify that for me?
Yep. As my recognition states, it's correct that I have been involved since March 2020. Now, when I say involved, it's when I was asked if I could recollect anything about the roofing contract that took place, and in particular the roof at Drybrook. And I have been involved over in that area at the blocks when the roofing was being proposed and the one at Drybrook took place. There was window installations took place, but I do not and have not been involved in the block for day-to-day routine maintenance repairs.
Thank you. So yeah, just to clarify on that, day-to-day routine maintenance, or in fact any oversight of it, would not relate directly to your experience or responsibilities.
That's indeed correct.
Right. Okay. So I'm just a bit confused about that, to be honest, Mr. Miller, because in the next paragraph 1.3, section 1.3.1, states that your evidence will address the council's approach to maintenance. If you're not responsible for that maintenance or any oversight of it, what would qualify you to speak to it?
The responsive repairs and the capital investment were pulled together as far back as 1998, when the creation of the Repairs Management Centre. Now that is a large open plan office at Broomhill in Kirkintilloch, Broomhill Depot, where the maintenance and the investment worked hand in hand, and that involved myself and my team for the capital investment, but also working with the repairs officers and their superiors as well. And it was a case of focusing and close liaison with each other, because if we were going to, for example, a kitchen replacement programme to meet the Scottish Housing Quality Standard, then it's pointless if there's repairs sitting on the system and repairs are undertaken, say, for example, supplying fit to kitchen cabinet doors, and then a couple of months later the contract would start for replacing kitchens. That would be a waste of public money and a waste of the revenue. So with the repairs, in terms of day-to-day routine repairs and the capital investment for planned works, that dovetailed neatly together. And that still is the case today, whereby we communicate regularly and we have meetings as well.
Yep. So, in essence, your sort of close liaison with the team who do this work is what you know about that. Thank you. So, yeah, on the subject of kind of maintenance then and capital improvements, paragraph 2.1, council operates two specific forms of maintenance regime, so planned maintenance, reactive maintenance, and they're both funded from the council's housing revenue account. Is that correct?
That's correct.
Yeah. Are you familiar with the council's housing revenue account? Would you be able to tell me a bit more about what that is? Would you be able to tell me a bit more about what the housing revenue account is?
Yeah. The housing revenue account, effectively, when you're using the revenue account for your repairs, you're in effect using the rent money. And those repairs will always come, standard routine repairs, will always come out of that particular account. Now, it also funds planned maintenance for annual gas safety, and that's a ring-fenced section within that budget. And the capital investment, that sits alongside the revenue, and that's why there's such a close liaison is required, and it's to make sure that work is not being undertaken which would be superseded in a very short space of time with the capital investment, because it's important to make sure that the money is spent in the correct way.
Yeah, thank you. So, yeah, just broadly speaking then, it'd be safe to say that you would generally be aware of such capital investment in your role, roughly, I mean, not to specifics.
Yes.
Yeah. So, generally then, would you say that the housing revenue account is operating at a deficit, i.e. the housing revenue account is capital structure is in debt, or would you say that it's operating at a surplus?
I don't have any figures with me today, and I would say that that is a question which would be put to officers above myself, because clearly any debt provision requires to be provided for in the housing business plan.
Absolutely. And yeah, of course, without again going into specifics.
We'll know how every council works, but he's not responsible for finance, and I don't think he's the appropriate witness for these questions, Mr. Ferguson.
Yeah, really what I'm trying to clarify here, Ma'am, is, Mr. Miller, would you say that if the HRA was operating at a deficit, that it would be unable to perform such repairs?
No, Mr. Ferguson, I've made my position clear on this. Mr. Miller is not the person to ask about the council's finances.
Paragraph 2.2, so works that are funded under planned maintenance includes annual gas safety inspections and external colour washing and close painting programme. Would that be the external painting of the building? So, for example, Block 2 or Block 1 when it existed at 8 to 28 Nithsdale Crescent?
There was no external colour washing to any of the blocks, Blocks 1, 2 or 3, because the colour washing programme itself, colour washing should be applied to wet cast and not dry cast. They're two different finishes, and the blocks at Nithsdale are dry cast, Therefore, there would never be any external colour washing, but there would be and should be close painting.
Thank you. So yeah, that, even though that would be funded under planned maintenance, that's something that's never actually happened, correct?
You mean the external colour washing?
Yep, or close painting, the close painting programme.
The external colour washing never occurred because it was never instructed.
Yeah, and the close
But
painting programme.
There has been painting.
Where has that happened?
Pardon?
Where has that taken place? That painting?
We're getting into repetitive evidence, Mr Ferguson. Mrs Ferguson has given her evidence and Mr Miller has responded to it as best he can. I have him on that. There's no need to go over it again.
Okay. Thank you, ma'am. In your dialogue there with Mrs Ferguson, you spoke about the council specification of colour. Would you be able to tell me which colour that is? Just.
I would not be able to answer that question because it was 16 years ago.
Right. So there's no longer a specification, is that right?
The present situation is that our in-house contractor, property maintenance, have just recruited a team of painters and are in the process at this time of almost, we want to call it, recreating a close painting programme, but also tied in with that a gutter cleaning programme as a part of a new approach to pre-planned maintenance, which is distinctly different from the capital investment. That would also be funded by the council's housing service, housing revenue account.
Yeah, thank you. So yeah, just on the subject of that, the planned close painting programme that you just mentioned there. So that's in paragraph 2.2 of your recognition. Yeah, it says at present the council is proposing to re-establish a planned close painting programme across the stock. How can you re-establish something that was planned so that, to the best of my knowledge, and potentially you'll be able to help me with this, never actually took place in the first place?
Mr Ferguson, I've got the same concerns. I mean, the close painting situation, Mr Miller's explained his position and Mrs Ferguson's said what her immediate experience was. I'm not really clear how much more is to be gained on this. I mean, some of the questioning that will be directed at Mr Miller is into areas where I've made it clear there are problems about how relevant they are. I mean, I'm well aware of the objector's concerns about past performance, and because it's quite difficult to distinguish what is and is not important here, I'm allowing a bit of rein on questioning instead of ruling them continuously out of order. So I am already being a bit kind of lenient here, but we do have the position on the close painting of Dryborough, as Mr Miller has given it, and we have Mrs Ferguson's evidence, which she's given in questioning, but never mind, about the lack of it in the Nithsdale blog. I don't think there's any more I need on that.
Thank you, ma'am. So, yeah, moving on, Mr Miller. Paragraph 2.4 says that HRA expenditure must be justified given that it's finance that's raised via tenants' rents. So accordingly, it's essential that such expenditure is not utilised to supplement or meet the cost of works for homeowners, as they have a responsibility to pay for such works that are common works, common repairs. I think, like we say, it's already really been established that these repairs haven't been performed, to the best of my knowledge. I'm aware they're on the system, but are you aware of any repairs that have actually been performed at Nithsdale Crescent that you've seen that have taken place that are on the spreadsheet that's been provided or anywhere else?
Whether he knows whether any shares have been recouped from the owner-occupiers in Nithsdale?
No, ma'am, just putting forward that these repairs have not been performed. The common repairs, that is different to just general painting or anything else, and I'm just trying to establish whether any common repairs have been done that there's evidence for. because I haven't seen any.
Well, again, I really think I've got enough on it. Mrs. Ferguson started the process. I chipped in, and we know the limits of Mr. Miller's knowledge. And knowing that limit, I'm not sure that there's much further we can take it, because he did say specifically that he explained what the spreadsheet was, and he explained the limits of his own knowledge. He also told us what normally happened, but it's clear that there's a limit to what he can say by way of verification. So I'm not sure that going over this ground is likely to be productive from my point of view.
Okay. No problem. Thank you, ma'am. So just on this policy that you mentioned in paragraph 2.5 of your recognition, Mr. Miller, I'm quite interested in this, specifically the wording, where it states, where a tenant wishes to request a responsive repair, the tenant may do so by contacting the council's customer contact centre. This was touched on as well in discussion with Mrs. Ferguson. In paragraph 2.6 it goes on to say, where a tenant or owner wishes to request a common repair, they may do so by following the above process. As far as you're aware, would owners have been informed in any way that they were able to use the same process which explicitly refers to tenants in order to request the same works? Because that doesn't really seem to be clear.
At the time when the repair centre and these processes all come into being, I'm unaware of any. It would have to be a circular sent across the entire stock to all homeowners in mixed tenure blocks to advise of that. Now, what I can say is that at the initiation of the contact centre and this new concept, it was well advertised in the local press, and I know that numbers over the years, numbers of homeowners have made contact with the contact centre. Now, before I put the precognition together, I was aware of the process when the customer contact centre started to, it came into being and then started to blossom. So I took the opportunity to speak with a colleague of mine, George Russell, who is a repairs officer and who deals with this particular area and the flats that we're discussing. And what I put to George was, can you confirm or otherwise the existing process as I understand it, and has it changed in any way? And that is what's contained. That process is the current process as I have been advised by the repairs officer who covers this particular area, and that is a process that's applied as we speak.
Thank you. In your opinion, then, would it be fair to say that it's not, even though homeowners have over the years contacted the customer contact centre, from the wording of your precognition in paragraph 2.5, it seems that it's only tenants, so would it be fair to say that owners may not be aware that that policy could also apply to them?
As I've said, when the customer contact and the centre came about, this was advertised in local press. Now, I clearly can't say to this inquiry that yes, every tenant, every homeowner knows about it, because I simply don't know. All I can say is that the council, because it was a new concept, that they took every steps to make sure that the public were aware. And it was also, in terms of EDC tenants, it was well published and still is to this day as a standing advert in the housing publications that are sent through the Tenant Participation Working Group to community councils and tenants associations, and the contact centre details are there in that particular publication as well.
Yeah, and that's fair enough. Thank you. paragraph 2.7 of your recognition, you state that where a housing block contains a mix of tenures, then before instructing any common repairs, the council will generally ensure that homeowners commit to and make the required financial contributions for which they are responsible. Could you just take me through how the council generally ensure that?
That is a process which is undertaken by the repairs officers for that for that particular area. And if it's a common repair, what the repairs officer requires to do is to ensure the homeowner knows what the cost of the job is. That job is then broken down and apportioned accordingly, so that a homeowner understands this is what I'm due to pay. But they should also liaise closely, which is a key part of all of this, in my view, and be able to say, this is what is wrong, this is what we need to do to remedy the issue for your benefit, this is how much it's going to cost, and I've broken down the share for your own responsibility, and this would be the sum you would require to pay. Now, upon doing that, it's essential for the repairs officer to obtain a mandate from the homeowner confirming that they will pay that particular share. And that mandate should also show what that cost is, whether it be £50, £100, whatever it is. And it's also incumbent upon the repairs officer to be able to advise the homeowner when the job will be undertaken, who will undertake it, and once again, that should all be with the homeowner, because that is good dialogue. It's the way things should be done, and the homeowner should know exactly what they are signing for. And that's all it'll be, what you call it, the little steps that you would expect to give to a homeowner.
Yeah, thank you for that. And you just, I suppose, expanding on one point of that a little bit then, you'd say it would show the cost that the homeowner is responsible for on the system. Which cost, system would show that cost? Would that be the servitor system as well, or would that be a different system?
No, the system would you would only see the cost in the system once it's been agreed to put the job out and the system produces the job ticket. And what should happen thereafter is when the job's completed, signed off and all the rest of it, the homeowner should receive an invoice from the council's finance team. And it's a section within that team called sundry debtors. And it's simply the account, the bill. Now, on the EDC 65, I did notice when I was scrolling through, I did notice that there was, there's 10 items relate to roof, and I did notice that one of them referred to owner-occupier share of costs. No? It's EDC 65, ma'am.
I believe that's a spreadsheet, ma'am. Yeah, would you be able to point out which entry that is for me? Which number? Or
just put that off.
no problem, take your time.
Ma'am, I can assist if that's appropriate. I think it's item 18, perhaps.
I honestly don't know what that means. Roof repair, owner-occupier share to number 48. Now, what I can't tell you from this, is the share £506.79, or is it a share of that, or is that the actual share?
Yeah,
Does it make it clear?
Thank you, Mr. Miller. See, it's interesting that, isn't it? Because share there, owner-occupier share, I don't think that's what that actually says. Looking at some of the other words around there that have O's in them, it looks to me like these are zeros. So I don't know what CRFR means either, but it says 10 roof repair, 0 out of 0 share, number 48. That's what I take away from that, because that appears to be a 0 and not an O, so that wouldn't actually relate to owner-occupiers.
If in fact your interpretation was indeed correct, then that would imply there has been no cost apportioned to homeowner.
Yeah, no, apologies. Just trying to be polite, Mr. Miller. Those definitely are zeros. Those are not O's, uppercase or lowercase. So, yeah. So basically, there's nothing in here that so far that refers to common repairs.
Mr. Ferguson, I need a wee bit of clarification for my own benefit. We're looking at a spreadsheet taken from the servitor system, which I think you've explained is for the sort of purchase order aspect of things. Should this be showing charges raised against owner-occupiers? Would we expect to see that in this? So it's not apparent to me whether that would be or whether it wouldn't be.
What I would expect to see, ma'am, is the cost of the job, a start date and a completion date. Now, beyond that, it would be the repairs officer who would communicate with the finance department and request that a sundry debtors invoice be issued to the homeowner.
So it sounds to me as if Mr. Ferguson's writing the O/O or 0/0, if he's right and that doesn't actually refer to an owner-occupier share, that would make sense, because this seems to me to be a list of repairs, many of which are common repairs. And so if it were to be the case that normally one would expect to find an entry in this showing the charge out to an owner-occupier, we'd see it a lot more times than just once, wouldn't we? So that suggests to me that this doesn't, that any charge out to owner-occupiers isn't supposed to appear in this. Right? So the repairs officer takes the costs and then in a separate financial exercise passes it to finance, and then it's up to finance to collect it.
That's correct.
Is that right? And if you've explained that a good common repair would entail the repair officer undertaking close liaison with the owner-occupiers, and you mentioned a mandate, that suggests to me that it's the housing officer's responsibility to carry out a separate exercise to collect costs. Is that actually the way it works?
The mandate is crucial because it's effectively the commitment by the homeowner.
I'm going to come back around to the mandate.
Oh, right, okay.
I'm going to come around to the mandate in a moment, but what I want to clarify is whether there's any basis for suggesting that we can see the charging out of common repairs from EDC 65. And I think what it looks to me certainly, and I could, if you're in a position to rebut that, that's not what this does. So we can't see the charge out process in this. Might I be right about that?
Yeah.
Okay. So that's cleared that up as much as I need, Mr. Ferguson. But do you have further questions about it?
No, I'm happy with that, ma'am. All right to carry on. Yeah, so just on the subject of this document, Mr. Miller, there's been a bit of confusion about it, obviously, during this whole process. And one of the ways in which I attempted to corroborate some of this information and clear it up to get to definitive answer one way or the other was to submit a request for the information to East and Barnshire Council. Now, it probably, in retrospect, would have been better addressed under the Freedom of Information Act for Scotland 2000, but it's been responded to under the Environmental Information Scotland Regulations 2004. That's document EDC 132. Have you seen that document?
No.
No.
I made it clear where I didn't consider that the production of information fell within my remit. So if you would bear that in mind as you proceed.
Absolutely, ma'am. Are you able to see that document, Mr. Miller? So there's a section there that says documents which have not already been submitted. So that's page 2.
Sorry. Hang on a second, Mr. Ferguson. It happens not to be in my bundle, this particular one. Give me a moment, would you please? So it went in a different place, so just, sorry, bear with me. I have it, right. Carry on, Mr. Ferguson.
Thank you. So yeah, that section on page 2, Mr. Miller, the documents which have not already been submitted. Question 1, which is a question that I put to request that information, was the details of all contractors used by EDC for the repairs listed in EDC 65, including forenames, surnames, dates of work carried out and contact details, as well as the missing maintenance period from the last date listed in ED 65 to the present date, which as at the document was the 29th of October 2020. And I said that, as I've just told you there, that this was necessary to corroborate the information presented, as there are serious concerns so as to its factual accuracy. What I'd really like to ask you, Mr. Miller, the response I got to this request essentially says the Council does not hold this information requested in a collated form. However, we've just kind of gone through the servitor system and how that relates to that it is held in a collated form. Would you maybe be able to clear up why the Council doesn't think that it holds it in a collated form?
It's really nothing to do with the proceedings today. And if you remember, I considered your request under the ambit of what I am doing and the application of the Act. And if you remember, in my finding on this, I made a distinction. So from my point of view, this falls out with my remit. Incidentally, the question of corroboration is a technical Scottish legal term. It's a long and eminent concept. It is not always applicable in court proceedings, and it's really terribly applicable in public inquiries. These are a different sort of proceeding, and the absence of corroboration is not necessarily something that is a fundamental difficulty. Just to sort of flag up to you that the absence of corroboration is not of itself something that's going to be of interest to me. As I said earlier on, I've just got to work with what I've got.
Yeah, absolutely, ma'am. I appreciate that. Thank you. So, yeah, just coming back then to paragraph 2.7 of your recognition, Mr. Miller. The sentence that reads, to that end, it's essential where the common works are identified as being required, the Council establishes the issue that requires to be resolved, the solution, the cost of the solution, how much of the cost requires to be apportioned, etc. I just want to focus in for a minute on the wording used there, the solution. So you just had, in your dialogue with Mrs. Ferguson there, a conversation about how, relating to when myself and other members of my family have been injured due to slip hazards in the building, that, in your opinion, one of the causes for that could be driving rain and open windows. So, to me, the first step of that, where that might require common works or at least a policy of some kind in mitigation has been identified. So what was the solution that was provided for that?
The issues that you discuss are issues that I would not directly be involved with. That would be the repairs officers as a part of their remit within their service.
Mm-hmm. And in your liaison with them, are you aware that they've attempted to reach any kind of solution on that issue?
This issue was never brought to me.
No. In paragraph 2.8 of your recognition, Mr. Miller, it states that the approach is also applied to capital investment improvements. Where homeowners do not agree to pay their share of costs and do not support the works, then the Council would not proceed with the works unless an alternative solution could be investigated. Now, capital investment is your area, Mr. Miller. What efforts have you undertaken that have led you or anyone else involved in the capital investment process to believe that the owner-occupiers, who are also the objectors to the CPO in Block 2, that's 30 to 50 Nithsdale Crescent, would not pay their share of the cost of works?
The issue with regard to the blocks here, and my involvement initially, was the roof, the sloping roofs that were put on, and one's already on, as you know yourself, one's already on Dryborough. Now, going back to 2005-06 financial year, that was at the start of the Scottish Housing Quality Standard period, which had legislation that had been brought in where all social landlords required to meet a set of prescribed standards by 2015. And not long before that, the Council had recruited a new head of service, head of housing services, Mr. Kenny Simpson. And I used to attend regular monthly meetings together with finance officers and estate management officers to discuss the programme of works which was being proposed, and to, on a monthly, say 5-weekly, it's hard to run to that basis, whereby we reviewed progress in terms of contracts, whether they'd started, where they were at, how the budget was running against the budget head. And one of the issues which was brought to my attention and I was asked to look at was a report, and from memory, and I have put it in here, from memory, it was brought to Kenny as Head of Housing Services via an elected member for the area, and that complaint was about the ingress of rainwater to the flats. Now, you know yourself that the flats have a flat roof, and one of the things that we investigated was what would be a better solution, and it was to pitch the roof. Now, I was asked to send communications out to both homeowners and EDC tenants, and we sent those communications out up through via the mailroom, and we did not get a response. I had no response from any of the team. Now, at a meeting several weeks after, I was asked, have you had any response, Colin? I said, at this point in time, Kenny, no, we don't have anything. We had already got costs from our in-house contractor, property maintenance, and those costs that were presented to us were provided to property maintenance by R. Tinning and Son, who were a subcontractor. The roof at Dryborough, and we were hoping it would have been 3 roofs, all had to be constructed on the flat roof itself and built up. And the DLO, the property maintenance, they subcontracted the work, but they were the principal contractor. I was then asked at a progress meeting to send out a second letter, which we did through the mailroom again. And a number of weeks later I was asked, do we have any further response? I said, at this point, no. And I was instructed to just crack on, get the one at Dryborough done, and once we've completed that, to come away from the site. And if there was a positive response in future, we would consider that to go back and do that. And that, in essence, is the potted history, you want to put it that way, of that particular issue, about how it came about.
Yeah, thank you. That's very helpful, Mr. Miller. Thanks. So yeah, just some of the things that have come out in there, just for clarity. So when you say that, unlike the member raised the issue of water ingress related to the flats, can I just clarify which flats he was referring to?
From recollection, it was at Nithsdale. I'm positive it was that. Yep. But it is, as I say, it's 16 years ago. Because there was 3 blocks, the decision and instruction I received was to attempt to roof all 3. And that's what we tried to do.
Thank you. Yeah, so I mean, Nithsdale just generally, so that could have referred to other blocks. Couldn't it? And Nithsdale, I mean, Nithsdale Crescent's quite a large area, not necessarily the site that's the subject to this CPO. It could be in other areas in Nithsdale. No,
it was simply the flatted dwellings.
Yeah. You said a number of communications were sent to the affected flats in response to this from the mailroom. What flats did you send those communications to?
The same letter went to both EDC tenants and homeowners to blocks 1, 2 and 3.
And is there any record of that letter, as far as you're aware, that's been submitted in evidence or is available anywhere else for us to have a look at?
No, I'm sorry. As I say, it was 16 years ago. I don't have a copy of that, and we wouldn't be keeping records for 16 years of a letter that went out to a tenant.
Don't have to. That's absolutely fine. Thank you, Mr. Miller. Just the last kind of point on that before we move on. You said you were kind of hoping it was going to be 3 roofs that went ahead, and then Clara did that you were instructed that it was going to be 3, but then later received instruction just to crack on with the roof at Dryborough and not the other 2 blocks. Did that instruction come from Mr. Simpson?
Yes.
Yes. Thank you. I just want to touch briefly on kind of the last part of that paragraph in your recognition that refers to the Scottish Housing Quality Standard. Brought in, I think it's 2006, 2007, around that time.
Yeah, it's the legislation that was to kick off in 2005 and conclude by 2015.
Brilliant. And that applies to social landlords, is that correct? So that's a standard for social landlords, the Scottish Housing Quality Standard. So, insofar as someone is not a social landlord, that standard would not apply to them, is that correct?
So, yes, it applies to local authorities, housing associations, etc. Social housing providers.
Yeah. So, while the council would, as kind of the majority, I suppose, owner within the building, who would have the real burden they're required to meet that standard. However, the other owner-occupiers would not. Am I right in saying that?
I believe, and possibly my colleague Ian could confirm, but I believe that there's now an expectation, possibly through legislation, I'm not 100% sure, so I'm being honest about this, whereby there is an expectancy by Scottish Government where homeowners, if they were, for example, subletting, where they would require to meet specific standards for their customer.
Yeah. That's actually really useful, Mr. Miller, thank you. So essentially in the event that, say one of the owner-occupiers here were to enter, or were to have entered a shared equity agreement, and their home was brought up to the Scottish housing quality standards, they would be submitted to, or permitted to sublet it, is that correct?
I don't deal with that legislation, and I can't honestly say I know anything about
Sorry,
it.
Mr. Miller. Mr. Ferguson, we've looked at the black and white on this. We've looked at the equity scheme, so we know about that.
Thank you. So yeah, essentially what that paragraph is saying there about the SHQS to me is that overcoming the difficulty of homeowners refusing to meet their share of common repair improvement works, as it's now an increasing problem. They don't really want to take court action to recover sums due from homeowners, as it's undesirable, uncertain and expensive. Insofar as we have addressed that, we've addressed the black and white of it, that private owners would have a responsibility for that common repair, were it to involve their part of the property in so much as they own it. Surely that's black and white legally, that it wouldn't be difficult to recover that cost from them. They have a legal responsibility to meet their share of the common repair work. So what is it that would be uncertain and expensive about that?
Ever since the inception of the SHQS, we have encountered difficulty, in particular with the re-roofing of mixed tenure blocks, whether it be four in a block or flatted property. And despite small success in some areas, we still have a number of properties which in that particular aspect of the Scottish Housing Quality Standard, that roof is failing. That is because the homeowner or owners, some are 50-50 share, have an unwillingness, I'll put it no stronger than that, an unwillingness to participate and pay their share. Now, these in housing terms are kind of known as blockers, because it's just a term that's used that this person or persons would be blocking the ability to meet the particular part of legislation by refusing to participate. Now, the Council have tried and continue to do so, and are having a limited level of success through framework agreements with contractors. There's a number of properties ongoing just now where it's mixed tenure, and but we still have a bit of a way to go, because we have these pockets of difficulty dotted about the stock in different areas. And one, I would put it no stronger than one common theme that we get is that I can get that cheaper from another contractor. I've got a friend that's a roofer. These are daily things that crop up, because when you present the cost, it can look a bit daunting, and we try to explain that what it involves in terms of rainwater goods, removal of that, replacement, lead flashings. It depends also, the cost also depends on the type of roof, whether it's a straight up and over, whether it's a roof with hips. It just depends. But we have costs from, and we have frameworks from contractors. But it is a difficult thing to get through and to let people understand as well. And I know my colleague Ian is working on looking at different approaches, because we will still have this issue if we didn't have a look at the approaches and what could we do.
Yes, certainly, Mr. Miller. I think that would be productive. Sorry to interrupt you. Thank you. Just before we move on to kind of paragraph 2.9 of recognition, just want to be really clear. So the reason the two roofs were not built on 8 to 28 Nithsdale Crescent and 30 to 50 Nithsdale Crescent, now I accept that you're not responsible for that, that you were instructed to do that by a superior.
That's correct.
To the best of your knowledge, why would Mr. Simpson have instructed you to crack on with Drybra and not with the other two blocks?
At the time, we had the contractor's cost, and they simply wanted to get on with the job. And I think it's fair to assume that Kenny took the view of, you're using up officer time, hourly rate for your wage, and if you're getting nowhere, that time could be better spent dealing with something else. And then, hence, as I say, he said, look, Colin, just crack on with that one, get that one done out the road. If something crops up and the people are willing, then great, we can revisit it. But let's crack on with that. And that's exactly what happened.
Yeah, thank you for that. So, just kind of specifically, you mentioned people being unwilling to participate, given the cost can be daunting, and I can see that obviously being a reasonable suggestion. In your experience, particularly as it relates to the proposed site for development, so where 8 to 28 formerly was in Block 2, 30 to 50 Nithsdale Crescent, did you ever have any encounters with any of the owner-occupiers that indicated that they would have been unwilling to participate in paying their share of the costs?
No, not face-to-face. Everything was put out through the mail.
Yeah. Okay, thank you. So, yeah, paragraph 2.9, where the cost of the capital investment improvements is disproportionate to the value of any privately owned properties, the council would take this into account in deciding upon an appropriate strategy. Now, you just touched briefly on the end there about the formulation of alternatives to kind of overcome these difficulties, which I think we all agree is a sensible solution. What that would suggest to me is that there would need to be some consideration of the ability of those involved, so essentially non-council owner-occupiers to meet those costs, and that would be worked into that strategy. Would that be fair to say?
That strategy, or any strategy, there's not been, how could I put this? This goes back to, let's say, 16 years ago. And at that time, there was no formal strategy, but it is a situation which is presently being looked at, and what's under consideration just now is a thing called missing shares, but I have no involvement in that. So they are trying to, the council as a service, as a housing service, they are trying to look at ways to assist the process for homeowners, but I'm not directly involved in that, therefore I would find that difficult to actually expand upon for you, Mr. Ferguson.
No, that's all right, that's more sufficient, Mr. Miller, thank you. So yeah, just kind of moving on then. Maintenance at 30 to 50 Nithsdale Crescent, paragraph 2.10. I have been advised by colleagues within the Council's Housing Services Management Team and Repair Service, who you have liaison with, that in the subsection 10.1 there, the maintenance regime described above applies and has applied to the 2 blocks of flats at Nithsdale Crescent. Obviously, there's 3 blocks of flats, or were 3 blocks of flats. There's 2 blocks now at Nithsdale Crescent. I can take it the 2 blocks you refer to would be 8 to 28 when it existed, and 30 to 50. Is that correct?
Yes.
Yeah. Now, as we've seen already, there are a number of inconsistencies that we're unable to define with that. So, do you think that that's an accurate relation to you by your colleagues within the Housing Services Management Team and Repair Service that the regime described above applies? Do you think it has applied based on what you've heard today?
I can only take what my colleagues are telling me. I've asked a question. They have confirmed to me. Therefore, I don't believe that I'm in a position to say that's not factually correct.
Yeah, I mean, you said already in your recognition as well, and in discussion with Mrs. Ferguson, there was no decision to reduce or alter the maintenance regime as a result of the decision to redevelop the Nithsdale Crescent site. Essentially, this causing a bit of a problem for me in understanding this, because you know, there was a decision to alter the maintenance regime insofar as it relates to the roofs, at least, and that would have been, we've heard from various other people about how that would have been necessary to prevent water ingress, given the nature of the flat roofs and the problems that have been described with them. Do you think that's accurate from what they've told you?
I wouldn't have said that the roofing was maintenance, because it's capital investment, it's an enhancement, and they're two different things altogether.
If that enhancement were done for the purposes of maintaining the building, i.e. creating a superior roof, would that not also be a form of maintenance?
No.
No. Okay. Yeah, unfortunately, Mr. Miller, I'm not the best one to speak to this, but I'm sure Ms. McMillan would have some insight on the subject. Paragraph 210(4). At no point in time has there been any form of factoring arrangement in place at the blocks in question. So formally or informally, do you think it's true that residents haven't or wouldn't have in the past contributed to common repairs or other types of work that were necessary?
I can only refer to that in as far as I asked the question of the Executive Officer, Housing Services, Grant McIntosh. Grant in turn made contact with other officers, as I've indicated earlier on. And the simple question was, can you advise me if there has ever been, or are, as at present, anything at all, can you advise me, has there ever been a factoring arrangement in place for the customers at Triber and Nithsdale? And every officer came back and said no. And therefore I have got to take that as, that's the factoring would be something that would be done through estate management, through the housing service. And therefore I've got to make a fair assumption to know what they're talking about, and I would find it difficult why they would tell me it didn't if it did. And therefore I've had to put down exactly.
I mean that's it. It's fair enough, isn't it? If they didn't check and then they told you that without having checked, you're not going to know that either. So I appreciate that. We can just move on to paragraph 3 of your recognition, repairs expenditure. So paragraph 3.1 states that council records show, and obviously refers to document EDC 65, that between approximately June 1999 and November 2018, £52,575 was spent on repairs. From what we've heard about the servitor system, it's a system that logs the capital expenditure, but not necessarily of repairs. So would you agree that those records are not actually evidence that much money was spent on repairs?
Can I just clarify, Mr. Ferguson, the servitor system records all of the responsive repairs and the costs. Where we would employ the in-house contractor to undertake investment works, they would raise tickets accordingly, and that would be on it. If we were undertaking work within the investment portfolio, and we were going to instruct that as an external contractor, that wouldn't show in the servitor system. That would come through a purchase order and a contractor appointment via the council's internal procurement team.
Thank you. Yeah, I mean, it's really the question of how much this relates to the repairs. I mean, we've already said that from the 10% checks, logically it follows that the council is unable or does not validate 90% of its expenditure on these repairs. So therefore, even though they're on the system, there's no way to confirm that they actually took place. Is that the case?
That is something which I would be expecting the repairs officer to respond to. As I said, I don't go through accounts and repairs because I'm working on investment. And once again, I double-checked what the internal processes were, for my own, make sure I knew myself, and then nothing of dramatic change had occurred over the time. And that is what I was told by my colleague, George Russell, who is repairs officer for this patch. And it's a 10% random check.
Thank you. Thanks for that, Mr. Miller. Yeah, so I don't want to labour that point too much, so I'll just move on. Paragraph 4, the block at Tribury Road, the improvements there. So during 2005, I was asked by the Head of Housing Services to include the 3 number blocks of flats. Just to clarify there, 3 number, is that all 3 blocks of flats? So Dryborough, 30 to 50 Nithsdale Crescent, and 8 to 28 at the time?
That's correct.
Yeah, thank you. Yeah, at Nithsdale Crescent, Bearsden, and the Housing Capital Investment Programme. From memory, I believe that the request was instigated as the result of an inquiry from a local member. Do you have any more detail on who that local member was, or that we could contact them to figure that out?
I don't recall who the member for that particular ward was. It was so long ago, and there's been there's been elections since.
Thank you.
Mr. Ferguson, why do you want to know which elected member?
We've not actually seen any evidence of this account, ma'am. So if we knew which elected member it was, surely they would know as they'd referred the complaint. So it would just be a matter of contacting them.
I think what we can, I mean, Mr. Miller's account of the circumstances is perfectly clear. That's the evidence before the inquiry. I'm still not sure why you want to find out which elected member was involved in 2005.
They would be able to, not in any legal sense of the word, but simply, generally speaking, corroborate this account.
Well,
to give substance to
it. I did explain to you that corroboration had very little bearing on what happens in an administrative public inquiry. I don't feel the need for corroboration. I think the situation here is perfectly clear. The existence of rain ingress is freely admitted, but I just don't see any relevance in trying to find out who the elected member that was involved in 2005 would be. It certainly is not information I feel the need of.
That's fine, ma'am. Thank you. Paragraph 4.2 of your recognition, Mr. Miller, it says, given that the existing roof was flat, it was decided to pitch the roof. Could you explain to me what that means, pitching the roof? Is that tar pitch?
Pitching the roof, the roofs as they existed at the time before the work were flat, as you know. And it was decided to pitch the roof to address the issue of replacing the roof, but also to ensure that some of the issues which existed at the time, ponding of water, it meant that if we pitched the roof, there would be a natural runoff for rainwater to go into outlets and then be discharged from the building by the downpipes. Whereas the roof as it was, and as still is, and your own block 2, will potentially suffer from a number of issues over a long period of time, which will potentially create future potentially rainwater ingress, which would affect the people in the block.
Yep.
Now, the roof itself...
Hang on a second, Mr. Miller. I think we really have had we've had at least 3 witnesses talking about the type of repair that you could effect on the standing block. I don't think I need Mr Miller to expertise deployed on what those were. I think I've got enough about that. Can I ask you, how many more questions from Mr Miller do you have, would you say?
Roughly, ma'am, it's up and down because it obviously depends on if there are any sub-questions that come out of that, but anywhere from kind of 30 to 50, most of them quite brief.
You've got 30 to 50 questions of Mr Miller?
Most of them quite brief, ma'am. Yeah.
Sorry?
Most of those will be quite brief. Just as an estimate, I don't know.
From years of deep experience, Mr Ferguson, I find that a very difficult proposition to come to terms with. Mr Miller's evidence is in his recognition. What additional information are you wanting to get from him?
So on this particular point, yeah, I completely agree that we've seen enough about the roof.
Yeah, no.
And so far,
if you've got 30 to 50 questions, what do those 30 to 50 questions relate to?
The content of this recognition and points of interest.
No, the topics. Which topics do you wish to examine?
I did wish to examine, ma'am, the improvements to the Lockett Dryborough Road in a bit more detail, and the impact of the redevelopment and future maintenance.
So you want to know more about the Dryborough project?
Yes, ma'am.
Aha. So that's one thing. And what was the second thing you wanted to know about?
So section 5 of Mr Miller's recognition, the impact on redevelopment and future maintenance, particularly his experience of that, his knowledge of that.
So these seem to me to be two legitimate topics, but I don't see 30 to 50 questions between the two of them. Is there any other topics that you wish to examine with Mr Miller?
No, ma'am.
Right. So you want to know about the Dryborough job?
Yes, ma'am.
Well, shall we move on to that then? So if you have questions for Mr Miller about the Dryborough job, let's get them through then.
I wonder, excuse me, ma'am, if we may take a quick comfort break.
That's why I was kind of asking.
Oh,
him. I thought I'd keep momentum up. Ms Hamilton is making a reasonable suggestion for a comfort break. We'll do that. We'll come back at 12:10. Mr Ferguson, would you use the break to focus in on the questions you wish to ask Mr Miller that will be helpful to me in my investigation? And, be a bit more rigorous with what you're asking about. Okay, 12:10, everybody.
Mr Miller, when was the last time you were in the Dryborough block?
I was over at the Dryborough block about 10 days ago.
Who was with you when you went there?
Just myself.
Just yourself. So, did anyone else? Did you speak to anyone when you went there?
No, I made 5 or 6 attempts with the handset. It was a warm day. The windows were open. I could hear televisions. I could hear voices. And my purpose, as I think I've said earlier, my purpose for going over was just to see the condition of it, because, and I'll try to assist the process during this question. There's work's just been released for that block at Dryborough, but I was unable to get in, physically gain access into the close.
Thank you. Paragraph 5.1 of your recognition. Redevelopment of the Nithsdale Crescent site as proposed will undoubtedly bring benefits to both residents and council alike. In the event that this compulsory purchase order is confirmed and we are left, as far as we've been led to believe from what we've heard from other witnesses, homeless, would you please tell me how that would benefit me and my family?
When I put that statement together, what I was referring to is that if the council construct new homes then the people who would occupy those homes would have a benefit in terms of, for example, thermal efficiency and reduced costs for running heating. They would be in homes which, if you took roof, then that would have, if it's a concrete roof, that would have a typical lifespan of 60 years, and you would expect a lesser number, in the initial stages, a lesser number of repairs being reported through the repair contact centre. Now, with regard to the tail end of the question about being homeless, I wouldn't wish to comment on that because I wouldn't wish to see anybody homeless.
No, I appreciate that, Mr. Miller. I think nor would anyone here. It goes on to state that modern construction methods and materials will bring, by and large, reduced building maintenance. Generally speaking, is it not true that modern construction materials will favour affordability over quality in the majority of cases?
No, not necessarily. If you take a look at the construction methods, you'll know yourself, Mr. Ferguson. You'll have seen new developments. Calla Homes is an example, where it's the timber kits. Now, they are modern day standards. They are highly, highly, highly energy efficient. If you take a look at one of the major components, which would be a roof, then all your roof line, your fascia, your soffits, your rainwater goods, all made in plastic. They are made in plastic, and it's up there. Now, in terms of the fascia, soffit, any barge boards, anything like that nature, and that these are dependent upon the design, of course, of the roof. These are, by and large, maintenance-free for a long period of time. They do not require to be painted because it is a PVCU finish, and therefore there's there's a non-requirement for painting in that regard. If you take a look at entrance doors, whether they be back or front if there's houses with gardens, then you will find the majority of these doors nowadays are composite doors with a 5-point secured by design locking system. Depends what obviously the council would specify what they would want. So it is very fair to make an assumption that most certainly in the early years you would have a reduction in the number of requests for repairs through the centre. There are various methods nowadays of construction. I'll give you an example where there is a factory in Cambuslang, and it is a part of the CGC group, whereby the component parts of a house are actually constructed within this factory, and these walls will come to site and they'll be craned off. Now, these walls will have the aperture for the windows and the doors. They will.
Sorry to interrupt you. Thank you for your answer. It's definitely, I think, been sufficient for me and likely for the reporter as well. Just specifically in relation to that, so that's the flat pack homes you're talking about. Yeah, and that's a colloquialism that's used to refer to them. Yeah. Okay. And you just, again, one point of clarity on that. The CGC group, would that be the CBC group, or is that a different group?
No, it's CCG. It is. My apologies. CCG.
Thank you.
I don't think going into the details of fascinating though they may be of particular manufacturers of prefab buildings in the west of Scotland comes into my remit at this time. The precise details of the potential replacement drawings, potential replacement buildings have not been brought into evidence, and so I'm not going to be looking at them.
Thank you, ma'am.
We've got the planning application, but that's all.
Yeah. So, yeah, just then, I suppose one last question. Mr. Miller, in your experience in capital investment, working for Eastern Bartonshire Council, and specifically as it relates to this project, given that we've touched on the capital structure of the housing revenue account, which again don't want to go into too much detail with, would it be your opinion that this is a feasible investment, and if that is the case, that it provides good value for money, and why?
Can I just be clear, you're talking about option 4, the Council's preferred option?
Yes, ma'am.
Yeah.
I would not be able, Mr Ferguson, to comment on that. I have not been involved to any degree at all. As I said in my precognition, my first involvement with this inquiry was to provide information that I had because I was the officer at the time, in 2005. So I couldn't honestly, with all honesty, provide a view because I simply haven't been involved in any of that.
Sorry, I hate to ask you another question then after saying it's my final question, Mr. Miller, but I do have one more question relating to that. Have you seen document EDC 56, which is the options feasibility report, since the 2nd of March 2020 when you became involved with the block?
I did see it. I did glance at it. I did not go into it in detail the other day. There's so many papers attached to the, you know, the
yeah, of course,
the submissions to go through it all. It's hard going.
No, I agree. I've spent quite a lot of time going through it, and it's hard going. One of the things in that is a cost report produced by MB Langmuir and Hay UK Limited. Are you familiar with that company? Or
I did note that when I glanced at the papers. Yeah.
So the document EDC 131 is one of the documents. And that, could I just quickly draw your attention to that on the subject of kind of the value of, or good value of this investment?
Was it 131 you said?
Yeah, that's correct.
Okay.
Yeah. So, on the second page of that document, it talks about a number of, you know, various things which would need to be done, you know, necessary systems that would need to be installed. One of those is door entry. You spoke about the door entry at the dry block when you went to it 10 days ago. Seems quite robust. You know, you were trying to get in, nobody let you in. So that's working, isn't it, up there at least?
Yeah. Yes, it's certainly working. Yep.
If that
suggesting Mr. Miller should have put his shoulder to the door to test it?
Nothing of the sort, ma'am.
I'm sorry, was that a question about the Dryborough block?
Yeah, it's a question about the door entry system at the Dryborough block the other day.
We've established that it works.
Yeah. So, if it didn't work, would you estimate that £4,500 would be a fair costing to replace it?
I think these costings, they're very, very, clearly they're very rough to get, I would suggest, to get the discussion going. So let's put it that way. But we do, through the normal responsive repairs, we do undertake as an authority various repairs. We have a number of mixed tenure blocks across the housing stock, and a number of the door entry systems as they existed were timber. Now that's got a maintenance cost, and they've subsequently over the years been replaced with, for example, Newton Security was one of the suppliers. They can vary very much in cost. Number one, depends who supplies. Two, you're out in the marketplace for best value, so you don't know what your costs are going to be till your tenders are submitted. Number three, depends on the size of the aperture and whether you're going to have the door opening, obviously, and whether you've got a side screen assembly, whether it's glazed full, whether it's glazed half. Then you've got the electrical works, which are quite quite intricated. You have got the costs of handsets to every flat, as well as the intercom. So they can vary very much depending on what the client wants. It's very much depending on what the client wants.
Yeah, I think that's very, very safe to say. So, I only have 2 more questions. No, I'm absolutely sure on that. So, I'll get through them quickly. So on that, yeah, given that it's what the client would want, as far as you're aware, in the production of these costings by MB Langmuir and Hay UK Limited, are you aware that any consultation was taken so as to?
Ma'am, Mr. Miller has already explained he's not been involved in this project, or indeed this aspect of this project. We did have quite extensive discussion yesterday on the costings.
Ms Hamilton makes a fair point.
Okay, ma'am. It's just that. Finally, Mr. Miller, I know there in the dialogue you had with Mrs. Ferguson that while you're not directly liable for it, you appreciate that our experience throughout this process, and in fact throughout the time that we've lived there, is not the type of service that should be delivered to customers. And you apologised for that, again, despite not being directly liable for it yourself, so I appreciate that. I'd just like to ask, what do you think could be done to ameliorate that situation? Now that you've become aware of it, and the council are aware of the building and some of the issues that might have happened with it as they've been related, what could be done?
Do you refer to, are you asking the question, Mr. Ferguson, what could be done to the building, or are you asking me the question, how could we potentially look at things as described by yourselves, and how could the council deal with that now?
The latter.
Yeah. Well, first of all, and I'll say again, I really am sorry, Mr. Ferguson, for what you've experienced. Nobody, doesn't matter whether you're an EDC tenant or whether you're a homeowner, people should expect to get a good service from the local authority with regard to issues of a common nature that, for homeowners, that are raised with the council. I would be very disappointed if the council had no recollection, as you suggested in discussion, that you'd made calls to the contact centre. Nobody get back to you. They would pass them a note. That to me, and I've been in local government now coming up 49 years this year, and I like to think that the length of time I've been in local government, I still to this day want to provide a decent service, because that's what you're there to do. And I think that issues which have been described by yourselves and experienced by yourselves, if there are records to show that calls were made but nothing really actioned, then I think the council should address it insofar as they should most certainly apologise at the least. Because I just don't, I'm old school, I'll be right up front with you, and I don't accept a kind of sloppy service, because I don't think that that's what you're in local government for, or public service. And I certainly would not wish to be an individual who makes phones into the contact centre, lodges a complaint or a request, let's call it a request for assistance, and simply you don't hear anything. That's just not right. Now, some people might not like me saying that, but I am who I am. I've got my own standards, and until the day I retire, I'm not going to let those standards slip. And I think everyone should have a set of standards that they shouldn't let slip. And once again, Ms. Ferguson, I would just apologise to you. There's nothing I can do or say to help that, really. But I don't think that to receive, as I say, a sloppy service, I don't think that's good enough.
And I appreciate your values, your standards, and indeed your candour today in addressing that and for apologising for it, Mr Miller. So thank you, and thank you for taking the time to answer my questions. I've not got any more for you.
No problem. Thank you.
So is that you finished, Mr Ferguson, with Mr Millers?
Yes, ma'am.
Right. Now, that's 12:30. Mr Farrell, am I right in thinking you have got a fair number of questions you want to raise?
Perhaps not as many as you might fear, and I'll try and put them very succinctly.
Well, the question before me is, do we take a lunch break now? I mean, I do have quite a lot of questions. Well, I don't have quite a lot of questions. I have a few questions for Mr Miller. So we probably do need to come back after lunch anyway to accommodate my questions, even if not yours. I'm just wondering whether a break now would be a good idea.
I'm happy to press on, but I'd defer to... You ready for a break? We'll take a break, please. Thank you, if that's okay.
So, we'll break now, and if we could resume at half past 1.
Ma'am, I'd be quite happy with a shorter break if that assists, if people are wishing to conclude the early, but whatever suits the room.
Well, you know, Friday is a day when I think we've got a reasonable expectation of being finished mid-afternoon. So, you know, that's civilised. So we'll take a break now, and of course sometimes on a Friday, if you take a break, it means it's shorter in the long run. So Mr Farrell can focus his questions if he's taking a break now. So 1:30.
Good afternoon, Mr Miller. Thank you very much for your attendance in this and for the very open approach that you've adopted the process with. It's been very interesting to listen to your answers so far. I don't have much. You spoke to Mrs Ferguson's questions earlier about the line items of repairs. I would like to look at one of those repairs in isolation, and in the aggregate I'd like to look at a number of others, if that's okay. Do you have that list with you?
EDC 65?
I'm not sure of the submission number, but the spreadsheet, the list of jobs done, which 65. Thank you. Thanks very much. Now, the one that I'd like to look at in particular, it's the last one on the list, and it reads, Newton Doors, replace broken closed door with new door. Now, I'm assuming that Newton Doors is the supplier, is that right, or the contractor maybe?
Apologies. It's actually the manufacturer.
Thank you. Okay. Now, to put this entry into context, because I was using the building where, at the time it was replaced, and I've got knowledge of why it was asked to be looked at. The situation we had, and first of all, I think I'd like to ask you to describe to me the technical solution that we have there. I've got a layperson's understanding where we have a door which opens and closes, and we have a control unit of some sort which it incorporates the intercom system and also actuates, I think, what's a servo lock, a magnetic lock of some sort. Is that about right, or could you please give me a better understanding?
Yeah, that's a fairly reasonable description. The control panel will, once you've pressed a flat number, that will ring through in the flat, and from that control panel flows all the bits and pieces with regard to the system within each home, the phone.
Thank you very much. Now, the nature of the failure which resulted in the call made by whom I'm not sure, one of the residents at the block, the failure mode was that control panel no longer worked. You couldn't access the homes by pressing the buttons, and in turn they couldn't release the door. Now, I don't know whether the ability to release the door was still there, but certainly communications couldn't be established. However, the door wasn't locked. The locking feature had seemed to have failed, so the door was swinging open. So that was the failure mode. the door's not locking, the intercom's not working, and this is the line entry that talks to the repair that was implemented. Now, what that repair was the installation of the brand new door. Now, the door we had was, the door itself was fine. The control panel seemed to have failed. And what we were left with was a new door that had a mechanical lock, very much like the locks on this door on this building here. On the inside, you've got like a thumb turn, and on the outside, a mechanical key. The intercom was left, that control panel was left alone. So as a result of the fix, we then had a door which could be locked mechanically and an intercom system that didn't work. And the problem that we had with that solution was it was not fit for purpose, because initially we didn't have the keys on the day that it had been installed. And going forward, not everybody that needed access to the building had a key or any means of communicating with the residents who could let them in, because that control panel wasn't working. Can you explain why that was the implemented solution to the failure mode that I've described?
Unfortunately, I wouldn't be able to explain that, because that repair to which you refer would have been instructed by the area repairs officer. And therefore I'm unsure what type of instruction would have been given, or why that a decision not to have a full system, if you want to call it that, would be the case. I would have imagined if we have a situation where you could not provide a full operational system, then you would be going for a complete renewal.
So initially I thought maybe it was a mistake, like famously when the railway bridge got demolished, when in fact the instruction, because of the appearance of a comma, was to demolish the old signal box next to it. I thought it was, that sort of miscommunication. But on reflection, it's not, because the door that's been installed is one with a mechanical key, so a mechanical lock and key. So that was obviously felt to be appropriate. I can't see how it can be appropriate, because, as I say, there's no way of communicating through the failed intercom. Now, Mrs. Ferguson, at least Mrs. Ferguson and possibly others, made calls to report that this inappropriate solution had been developed and implemented, and we still have it. We have a sign on the door explaining this door isn't locked, because we can't use it as it is, so we leave it unlocked so that people can enter the building if they're not residents with keys, but have good reason to be there. So we have a notice, this door's open, because deliveries were being missed, because the delivery people would press the button, get no response, and off they'd go. So given that we have an unsuitable solution to the problem of the failed control unit, and have had since, according to this record, this EDC spreadsheet submission, since November 2018. Can you explain why it's not been addressed, and if there are any plans to address it now, and if there are not, whether it would be a good idea to introduce some plans to address this problem now?
Once again, Mr. Farrell, I would say that I'm not able in this forum to provide you with that explanation, because it is an issue which has been taken on board by the area repairs officer. I would expect that were there an issue, as there clearly is for yourselves, the least I would expect would be that issue be discussed with yourselves as homeowners, if you have an issue, as you clearly do, and the local repairs officer. I really am not in a position to comment on why a specific solution was actually put forward by the repairs officer. It may well be, and I'm just assuming here, it may well be that there's been some form of discussion between the manufacturer and the repairs officer about, and that solution which you presently encounter, that solution was made, an agreement reached between the manufacturer. What's the best way to tackle this? Now, as I mentioned earlier, the door entry system should be functioning, and it should be, you should have the ability to communicate through the intercom system with each of the independent flats. The service button should be working for postal services, and that should always be the case. Now, if the door's lying open, then quite clearly the fact is that the door entry system is not doing its job.
Thank you very much. We've continued to use the door. It's not presented any problems. We leave it unlocked. Delivery men come and go and leave valuable items on doorsteps, and because we don't live in a troubled neighbourhood and don't suffer from any of those security problems, it's not been a massive problem for us, thankfully. But thank you. You're kind enough to outline the maintenance procedure internally. I think you spoke to job tickets, which were raised for every job, and the 10% sample rate. The 10% sample rate, I understand, being because you didn't have enough resources to check more than 10% of the jobs that are done. Is that right?
The 10% random check was the information that was provided to me by my colleague in the repair service. Thank you.
So the only other question I have on this spreadsheet here then is in the aggregate, and that is in 2017 we have no jobs. In 2016 we have 4 jobs, and in 2015 we have 2 jobs listed. 2014 slightly more at 5 jobs. Going back to 2011 we have 16. So there does seem to have been a drop-off in the quantity of jobs done. But could you explain why you might think that a 10% inspection rate, when we're talking about no jobs, 4 jobs, 2 jobs in a fiscal year, is appropriate and couldn't be bettered?
I would take the way that question has been put, Mr. Farrell, I would take that that's a reference simply to Dryburgh and Nithsdale flats. The 10% to which I refer and which my colleague advised me is across the repair service as a whole, is across 3,600 houses.
So it's a proportion of the whole estate, and it could actually result in there being no checks done at any subject property. Is that right?
That is potentially something that could occur.
Would you agree with me, or rather, do you think that that's a satisfactory and adequate way of ensuring quality?
I don't believe that random sampling is a great thing at all. I would not like to think that any property would never have anything checked, but it is a possibility. Because I do accept 10%. It's rather small. But then again, what we have is we have an increasing stock because the right to buy legislation has gone. And my colleague Ian has got a new build programme. So the stock will therefore increase. Now, the actual number of repairs officers, that's fixed just now. Now, it may well be that at some time in the future that would be increased by another couple of officers, but that's looking into the future and I don't have a crystal ball. Nor would I have any say in that particular matter. That would be down to assessing the, the inspection requirements by the property maintenance manager.
Thank you. At Block 2, the block in which I have an interest and which is the subject of the CPO, many of these repairs, on the face of it, based on the description and the time frame, don't seem to have been completed. Do you have an exceptions inspection process. If you're getting lots of complaints about a particular site that perhaps the jobs aren't being done and there might be some sort of systemic problem, do you have an exceptional procedure where you might go out and inspect?
Not to the best of my knowledge.
Thank you. I would like to talk a little of the repairs at Dryborough. So I think it's well established that in the 2005-2006 timeframe, there was an intent to erect pitched roofs on the 3 blocks. We've got it on Dryborough, we don't have it on the other 2. And also Dryborough benefited from some external cladding, some sort of insulation applied to the building. Is that a fair assessment of the situation?
Yes, the pitched roof that was installed in 2005, as was, as I mentioned earlier, the plan to do 3. If I go back the way to 1996, when local government reorganisation took place, Strathkelvin lost its northern corridor and it formed Eastern Bartonshire with the former Bearsden and Mulgai. My first encounter over in that area was in 2005 for the roofs, for the investment. And that was my first sighting of the external fabric finish to the flats. Now, to the best of my knowledge, that is a straightforward render system which was put on by the previous authority, and that it's traditionally built property. And I do believe that either all of it or part of it, the cavity is filled. But the existing render was not something which has been put on in my time within Eastern Bartonshire. It was the previous council.
So can I extract from that there are no costs recorded for what that rendering cost?
No, you're absolutely correct there.
Thank you. So to the costs of the roof that was installed at Dryborough, there's a couple of conflicting values given. There's a value of 122k given in one of the EDC submissions, and I don't have the number to hand, unfortunately, of which that submission was. But in your recognition, you have a different value, 127,817. May I ask what the value in your recognition is based on? What do we have for records of what that cost was?
What I did do as I was compiling the detail for the recognition, I spoke with the area repairs officer, George Russell, because George has been about, like myself, quite a long time, and he well recalls the job. So we were able to extract the job ticket from the servitor system. Now, the 122,000 is a committed figure, but the final figure for the job to conclusion was 127, whatever it is. I've got it here.
Thank you. That makes sense.
Now,
unless you have anything else to offer.
Yeah. Now, what I would say, and I did mention it earlier on this morning, property maintenance subcontracted that work to R. Tinning and Son. And in any job that's subcontracted out, if the in-house service is not going to do it, there is an uplift. And the difference is the uplift. Now, that uplift is the cost of property maintenance managing the subcontractor. But property maintenance they're still the principal contractor and have the responsibility for delivery.
Thank you. So just to close that one off, the value in your recognition, which I've written down as 127,817, we do have backup in the form of actual cost data. Thank you. We took evidence from the architect involved with the feasibility study and with the structural engineer who performed an intrusive study of Block 1, which has now been demolished. And they each explained, in response to my question, that the blocks is of standard construction. There are no non-standard construction elements in the blocks to which they're aware. Is that your understanding too?
That's my that's my understanding, yeah.
And the construction, you're familiar, I imagine, with EDC, I think it's 62, the survey, is that right?
That be the structural survey? I haven't looked through all of that at all.
I don't want to go into any of the detail there, really, but I just want... that survey suggests that the block 1, which has been inspected, block 2 by extrapolation, because they're identical or very, very similar. The construction is external walls, double-skinned bricks, internal load-bearing walls, single-skinned bricks. According to the architect, the structural engineer was less willing to commit to them being bricks, but he confirmed brick width. And I think the inference is they're probably bricks, and I know them to be bricks. The floors between the individual dwellings, the maisonettes, are slab concrete. The internal floors within the maisonettes are completely traditional joists and wooden floorboards. Is there anything in that build that's novel, or anything in there that isn't typical of building throughout the UK and elsewhere for a very long time?
I would have to say that it's nothing different from what I've come across in 49 years in flatted property.
Thank you. And that sort of construction, does it have a short, finite design life expectancy? Would you expect that a building of that nature to need to be demolished just because of the passage of time after any short time? How long would you expect maybe that a building like that could be expected to last?
I have looked with interest, Mr. Farrell, and I've listened to proceedings with great interest. And that particular item, I know it's been discussed about lifespan, and that's 30 years.
Indeed, in an EDC submission, I think it was EDC 6?
5.
Right, thank you. In response to my objection, it was suggested that because of the inherent nature of the construction, the buildings had only a design life expectancy of 30 years. It was built sometime, certainly before 1985 from the structural report, certainly after 1972 from the structural report, and probably 73 from that same structural report. So come 1993, it's implied that that building was very much on borrowed time.
I believe that much discussion has centred around this term lifespan, and I find it interesting, the 30 years. I believe that what that really is referring to is the lifespan of components such as windows, external doors, that type of thing, that would require to be budgeted for through the housing business plan 30 years down the line.
Thank you for clearing that up. That makes a lot of sense. And to the point of components that may have a short lifespan, would you consider
interestingly enough, windows and doors have a 30-year lifespan. Concrete roof tiles have a 60-year lifespan. Slate roof tiles have 80. Asphalt has no more and a real push at 20. It usually ranges between 15 and 20. Central heating, for example, is 15. And I believe that it's been taken out of context. And I would also say I don't believe it's terribly well written, because I think it gives an impression that we would go and demolish those properties 30 years down the line from construction. Now, logic tells you that if the council were to build 100 new homes in the year 2021, they're not going to go 30 years down the line in 2051 and demolish them. But they will require to replace component parts that are beyond their usable life cycle. Now, these life cycles are life cycles that are used, suggested and recommended by chartered surveyors through the RICS. And what the council's housing service requires to do, and review about every 5 years, is to look at their business plan. Now, a business plan is a very, very interesting thing. When you look at a housing business plan, you're effectively looking at how am I going to make, how much do I require to maintain the stock portfolio over the next 30 years. Now, you have to have undertaken a stock condition survey so that you can start to extrapolate information, projected failure years. In constructing a housing business plan, you require to know how many houses do we have? What is our rental income? Because it's the rental income will help to maintain those properties. How many staff do we have? What is the staff wage bill? How is our rent arrears position
Mr. Miller,
looking?
this is all of itself very interesting, but yeah, I think the kernel of what we needed to know was your views on the lifespan of the components. So I think, and I think the point that you made earlier was that a council, a housing authority, or a housing association, or whatever, should take into account, this is me interpreting what you're saying, should take into account the lifespan of the components in order to plan forward for their replacement.
Yes, ma'am.
Thank you. Absolutely fascinating answer, and I could genuinely probably listen to you all day long. Thank you for that. The components, you spoke to windows and some of the components that have a finite lifespan. You're familiar with the nature of the flat roof. You talked to it earlier, and I think you suggested that might be one of these components. What's your view of the flat roof life?
Apologies. Over my time in local government, I have yet to see or hear from anyone who would want to construct property with a flat roof, simply because it does not have a great life expectancy. There are various problems that you encounter with flat roofs, because a flat roof should have a gradient for a runoff of rainwater into the outlets. Flat roofs tend to, especially in the winter time, when there's leaves all over, what have you, they tend to gather. It gives it a surface for gathering, unlike a slope, a proper pitch in a modern day house where the gradient is greater. That can then lead to the outlets blocking up, which in turn means that the rainwater can't get away freely. That also then, in turn, leads to ponding, where pools of water lie on the surface. Asphalt roofs create difficulties in terms of maintenance. And the asphalt itself, by its very nature and its composition, it draws heat in the warm weather. And therefore, there's potential room for movement at seams. When it cools down, and it's of a number of years, it can become brittle and therefore lead to cracking. Now, it can also lead to blistering. The only way you can get rid of a blister on an asphalt roof is to cut it and then try to seal it. That, in turn, gives you another maintenance difficulty. So, in all of my coming up 49 years, as I say, within local government, I have yet to see anybody have any good word about a flat roof. And certainly in the modern day constructions that I've seen, they don't even put them on porches now, because in canopies. They would use what they call a GRP canopy, glass reinforced product. They are used by the private people, you know, building an extension or a little porch or whatever, but that's their own choice. And it's interesting, I feel, that this issue of rainwater ingress in top flats, when an asphalt roof is put down, there will be upstands and there will be flashings. Now, those flashings are not traditional lead flashings like you would have on a normal roof. They are asphalt. And because of potential movement, what can happen is the flashing can remove itself from the upstand and in at the corners. If it separates over time, that's a potential for ingress of water. So it's another potential problem for you. And that is why many, many, many people would not look at a flat roof.
Thank you. That's a very comprehensive answer, and I think we clearly understand your view of flat roofs. Is that the sort of conversation that might have been going on in meetings that led to the plan to install pitched roofs on the 3 blocks sometime on or about 2005?
Yes, I mean, I was asked my opinion, and my opinion is roughly just what I said to yourself. And most people in housing circles and repair and maintenance and investment know of the issues that can occur. And there is a limited life, and in my opinion, for a multiple occupancy, that's just not the solution at all.
Thank you very much. So, in response to Mrs. Ferguson earlier, you explained the reasons behind and the potted history associated with the modified plan to install a pitched roof only on the 1 block. At that point, and I think I know the answer to this, at that point, did anybody in the room think that the roof was going to get better? I mean, what was the prognosis for blocks 1 and 2 from that point in 2005?
Clearly, by roofing 1, as I said earlier, we wanted to roof the 3. It's obvious to me that the condition of the roof in 2005 is not going to get any better. It can't get any better unless you do something with it, because it is what it is. It's the membrane's there. It has its fixed life. But there's something I would like to bring in, which I believe it to be possibly relevant to you. Going through the evidence, there is a copy of a letter under the Eastern Bartonshire Council title, the heading, I should say, and it's from Building Standards confirming that when the properties were built, a completion certificate by the Building Standards was issued in 1969. An application to build had been received in 1967. So I would say it's fairly safe to assume they were constructed, and there only is 3 of them. It's fairly safe to say they were constructed in 1968, because it would take a year to sign them off with inspection by the relevant officers of the relevant department. The reason I mention this and why I find it interesting, when they were constructed, the life cycle of that roof would have been no more than 20 years. That being the case, it's fair to assume, if that were the case, that the roof would have been due to be replaced 20 years down the line, which would take you up to 1989. Going on from that, if that roof was replaced like for like with asphalt, then that would take you up to 2009 for its next planned replacement cycle, based on condition. And I was instructed in 2005 to look at them. So that's coming, and that's me taking a 20-year life cycle. So I don't know whether that's the second roof or the first roof that's on it, roof covering that's on it. But it is fair to assume that the life expectancies are, as I said, and are actually pretty much spot on.
Thank you, sir. So there was a decision made not to proceed with the roof on the building I live in, Block 2. There must have been management discussions about that. The risks, I'm assuming, were considered at that point. And what actually happened in those meetings? What was? I can't for the life of me see what the thinking was in 2005 when the roof wasn't replaced. What did people think was going to happen next?
The obvious thing that would happen is it would be thereafter, once the decision had been taken, like, let's move on. If the people come back, let's go to it again. If anything, it was just simply going to be subject to the housing revenue repair system, i.e., normal repairs. Now, if rainwater ingress is being experienced, that would then, I've got to assume, someone's going to report that to the council. And at that stage, either an inspection is issued or an inspection request is issued by the repairs officer, or the repairs officer actually goes out onto the roof himself. In dealing with repairs, it's all about observation, diagnosis and correction.
Would be the future from the decision not to proceed around about 2005. So are you able to shed any light on that? On what I can't remember the name of the person who
Kenny
said to you,
Kenny Simpson.
Kenny Simpson.
Yep.
What do you think Mr. Simpson thought was going to happen when he called off the repair of Block 1 and Block 2?
I would have to take it, ma'am, that he's, what he thought was the same as what I thought, and that it's not going to get any better. However, in the absence of having an agreement, the housing revenue account through the repairs officers would have to deal with anything that came across.
Now, if I can look at it, sorry, Mr. Farrell, if you don't mind, I'm going to take this line.
Absolutely, please, ma'am, carry on.
Would you think that Mr. Simpson felt that having failed to engage with the council, the residents of, well, we're not talking about Block 1 at the moment. I'm less certain that we've got a factual basis to talk about Block 1 at the same time. But was it Mr. Simpson's view that having failed to engage with the council, if he left them under that bad roof for a year or two, they might be thinking differently in due course? Might he have thought about it from that point of view?
I don't think, ma'am, that I could actually answer that.
Thank you. I have lost my thread a little bit. Can anybody remind me what the last thing I asked was?
Expectations of management at the decision not to proceed in 2005.
Thank you. I have two questions about the decision-making process, if I may. The first one is, you've explained that a letter was put out twice, or maybe 2 different letters were put out, and no response was gathered, and that was it. Given the potential impact of not proceeding with the work, do you feel that everything was done to make sure that the letter may even not have conveyed the significance, the magnitude of the problem to the recipients? The recipients may not have understood it. Do you think everything was done to ensure that the people living in the block knew exactly what they were being asked?
Or what would happen if they didn't reply?
Indeed, ma'am.
What I would have to say in response to that is that it's somewhat regrettable that some form of formal meetings didn't take place. I think that it was a case of, well, nobody replied, what else do we have to do? And I can only, as an officer of the council, within that service, I can only follow what I'm told to do.
Thank you. And just to be clear, it was the no-go decision was based on the potential non-recovery of proportional costs by those owners. Is that correct?
Yes, simply because we had no agreement on paper to proceed, and it was felt at the time we don't want to go down this road further because you potentially could be ending up chasing bad debt.
Thank you. Is it not the case that in circumstances like this, a charge can be placed against the property such that when the property is sold or next changes hands, that investment costs can be recuperated? Is that not so?
These are decisions and parts of legislation that I'm not involved in.
Thank you. Can we talk to, please, how much money we were talking about? What was the blocker here? How many of the in block 2? How many of the units were privately owned, please, at that time?
In block 2, from recollection, and it is 16 years ago, Mr. Farrell, I think it was 3.
And
I could be wrong. I'm only saying my recollection, but it is so long ago.
Thank you.
I haven't been in. As I said in my recognition, I haven't. I came into this process March last year, so I don't happen because of the role I fulfil. I'm not always over in that area, so the makeup of the tenure is not something that would automatically jump out to me unless I'm involved in a property.
Thank you. And that was the number that I believed, but this was way before my involvement in Scotland, actually. But it does sound reasonable, and thank you. And we had budgetary figures for the roof repair of 122k per block. Is that right?
Yes. Then there was the uplift. Takes it to 127.
And the block has 12 positions. Is that correct?
I believe so.
So we're talking about 3/12 of the cost was the financial exposure of EDC at that time.
Yes, that would be that. Yes.
What would that be? About £30,000? Is that right?
It's 20 odd.
I believe the budgetary figure at that time, ma'am, was 122.
I think there were actually 11 flats in
Is it 11?
block at
Sorry.
that time.
Apologies.
Sorry to complicate the maths further. That's okay.
Pardon me, ma'am? It depends how many units we take. I think, Mr. Brodie, you just clarified that at that time there were 11. There is the 12th unit, which is on the ground floor. Who owns? Well, I actually have two interests here, ma'am. One of which is exactly that, and the other one is it 11th or 12th? What's the legal position on that 12th unit? Because it affects any apportioned costs for any major work. Yes, indeed. If you look to the proposed refurbishment plans of option 1 in EDC 56, I think it is, it shows the development of the refurbishment of the 12th unit, which is currently used for storage. So my associated question is, who's on the hook for that 12th of the costs?
Are we talking about Block 1, or in fact are we using costs that are associated with Dryborough?
We're talking about any apportioned costs in Block 2 based on...
What we're really reaching towards is the decision-making process in 2005, the decision not to proceed.
Yes, indeed. Yes, indeed.
So
the other interest is associated,
I think
yes.
the best we've got is if we carry over the Dryborough estimates to Block 2 and try and... I mean, it's not perfect evidence, so let's not get too hung up about how accurate we are. The council decision not to proceed, Mr. Miller, would relate to a potential exposure to the council of an irrecoverable debt. Let's talk about Block 2, which is 11 units at that time, 11 inhabited units?
Indeed.
Yeah. So, so a minute. I'll do it on 122.
I think you're correct in assuming it's around 35,000 per unit.
Yeah.
Sorry, for the 3 units, I should say.
Yeah, it's about that. So, so the potential exposure of the council at that time was you wouldn't get about £35,000 back, and that was enough for Mr. Simpson to decide not to proceed with Block 2 or Block 1.
That was the instruction I was given, ma'am.
Okay. I think that's enough as a collection of the factual position, Mr. Farrell.
Thank you for helping clarify that, ma'am. Yes, and would you agree with me that, given that this exposure value that's just been determined was the maximum exposure value, and there was potential to recover some, most, or even all of it through different means, maybe by sending more than a second letter and explaining to the owners the problem? Do you believe that was an appropriate decision at that time? Was that a decision that would have had your backing?
Ma'am, we've had quite a lot of discussion on this, and I'm trying not to jump in at every question that's asked, but I do feel we're straying somewhat far from what we're here to discuss, which is the merits of the current CPO.
There's some interest to me in some of this, because it has a bearing on the choices that the council has made and therefore the alternatives to the CPO, which is why I've been allowing the questions to range as widely as they have. But we are beginning to run out of road a little bit, Mr. Farrell. This is evidence which has been looked at, and I have the council's position, I believe. I know what the objectors' views on that are. So, as I say, I think maybe we might be getting to the bottom of the barrel, but if you want to see if there's anything else you want to ask.
Well, I'd like to thank you for allowing me to go this far. I was surprised that I got this far without being challenged, and perhaps it's a it's a line of questioning for those other mechanisms available to me outside of this process that you explained were available in previous days of this inquiry. Would that be fair to assume? Well,
not necessarily, because then I would have stopped you. But I think I've got enough on what we've been looking at. I've found that degree of light on why the council didn't proceed in 2005 to be helpful information to a degree. So, have you got any more questions, Mr. Miller?
I do, ma'am, if I may.
Yeah,
thank you. If I can just take a second, because I need to change my line of thought. If I can just have half a minute. Okay. Mr. Miller, do you have access to EDC 41?
Yep, that's it.
Would you please take a look at paragraph 3.9, which is headed option 1? Do you see that the paragraph starts with the do minimum? Do minimum is quoted. The do minimum option 1, as illustrated in the design team's options appraisal in Appendix 1, entails the refurbishment and modernisation of both blocks. Do you see that paragraph?
Yes, I see it, yep.
If we take a look at the appendix is actually the feasibility study which appears in 56, but there may be differences between the two associated with timing. So if we have a look, please, at Appendix 1 of EDC 41, the do minimum option 1 is...
I don't think it is different, Mr. Farrell.
No, I'm not suggesting it is. I'm just suggesting that there's potential for it quite understandably to be different. I don't want to assume that it's not. The financial appraisal for the do minimum option 1 appears to be heading 8.2 financial appraisal. Would you agree that that is the appraisal to which we're being directed, and can you see it?
Ma'am, I'm just wondering again where this is going, because Mr. Miller is not involved in the decision making relating to this project. Hasn't been involved in the feasibility study or any of these aspects. So I'm wondering if these are matters that really are Mr. Brodie's domain.
Why do you want to ask Mr. Miller about the feasibility study?
It's not about the feasibility study itself. It's about EDC 41, the document in which the feasibility study appears. Well, the reference to a do minimum option 1. And I was going to go on.
What's your question about the do minimum for Mr. Miller?
The question was going to be, we have a value for that option of in excess of £3 million and a description as a do minimum approach. And I was going to talk to the evidence that the architect gave, explaining that there are the value described here as a do minimum value is actually a maximal value of a range of solutions to option 1, and we have a value under option 1 that was quoted at less than £1 million. I think it was £635,000, which, in the context of EDC 41, referencing this financial appraisal of a do minimum approach as in excess of £3 million is, in fact, disingenuous.
But I think that's a question for the author of the document, Mr. Earley.
The author of the document, Mr. Earley, well, that document was authored by Mr. Earley, and we discovered in evidence the council from their brief. But
well, not the financial figures. As I understand the evidence, Mr. Earley said that the initial passages of that feasibility study had been a lift straight from the brief, but thereafter the work that he and indeed Langmuir and Hay did, I don't think he suggested any of that had been written by the council.
No, he didn't, ma'am, and he distanced himself from any of the financial numbers, referring instead to that contractor you just mentioned, like whoever they were. So he did talk to some of the values, but not with any authority.
Well, if you had more you wanted to put to him, you should have put it to him at that time.
No, ma'am. No, ma'am. That's not.
Mr. Miller's not here to speak to Mr. Early's report.
No, of course. And my issue isn't with the report. My issue is with the description of that option 1, valued at over £3 million, as a do minimum report, because we did have a costed option 1 at 600. I believe it was 635, 536. Much less than £1 million.
Mr. Miller's not the witness for this area of evidence, Mr. Farrell. This is all material that should have been put to Mr. Early when he was on the box. And I did think you did, in fact, put various questions to him in this vicinity. So, but they're not questions for Mr. Miller's scope of evenance. And
I misunderstood Mr. Miller's.
Reopen the evidence with a different witness who hasn't had an opportunity to, who's not the author of the document that you're scrutinising.
Ma'am, if I haven't been misunderstood, then I've misunderstood the scope of Mr. Miller's experience. I thought Mr. Miller was speaking to Council Capital Stock Investments. Is that not correct?
Mr. Miller is explaining the system within the council and his knowledge of the practical aspects of the report, as I understand the position.
Thank you, ma'am.
He's telling you how it all works in practice at the sharp end.
Mr. Miller, we spoke earlier about accidents on what were perceived to be dangerous stairs. Is that something that's within your area of expertise?
No, I mean, I mentioned earlier on that the potential for a slippy surface, and a slippy surface in a close on a landing potentially could come from the landing windows, the stair landing windows being left open in inclement weather. But I'm not an expert on surfaces.
That's exactly, well, inclement weather, ingress of rain through an open window, and also rain being walked in through the opening door. That's exactly how the stairs became slippy. Given that the accidents have been reported and the state of those stairs is one of my original objections, is it a surprise to you that nobody's taken a look at the stairs and maybe installed some anti-slip?
Mr. Farrell, we have looked at this. And Mr. Miller, I think, has aligned himself with some degree of disapproval that the damp stairs and the slippy stairs haven't apparently been addressed.
Thank you, ma'am.
So there's no need to go for that again. And you are getting close to my area, my exclusion zones.
May I try this one, ma'am? Mr. Miller, the feasibility study, the statement of case for the council also references that the block is blighted with vandalism. Do you have any anecdotal evidence or documented evidence to support that?
I don't have anything to support that. That's not the type of thing, issue, that would come to me in my normal working week. That's an issue, if you like to call it antisocial behaviour, that would be dealt with. Any antisocial issues are normally dealt with the housing estate management team.
Thank you. In your role, which I imagine is a senior managerial role, is that right?
Yes, before restructuring, I was a team leader with my own team for capital investment, and I've been following restructures since.
Thank you. So in that capacity, there's no no universally understood position regarding vandalism and antisocial behaviour at the blocks. Just by osmosis, you're not aware of those issues.
As I said, Mr Farrell, those issues wouldn't actually arrive at my door. It would be the estate management team and their team leaders who would address anything like that that's reported.
Thank you. Mr Miller, you spoke in your answers to Mrs Ferguson earlier about a subject which has been brought up many times, and I've captured the note, it may be wrong, as being a 2005-2006 housing standards.
That'll be the Scottish Housing Quality Standard.
And the intent of the council at that time to conform by, I think, 2015, is that right?
That's right.
I'm not familiar with the standards. I'm genuinely interested to learn what the scope of those standards is. Are these standards that are to be applied retrospectively to extant buildings?
These standards were set, and it's the duty of every local authority, the housing service, to comply. The SHQS, as it's known, commonly known amongst council staff, comprises of 5 criteria. One is below tolerable standard, one is modern facilities and services, one is energy efficient, another is free from serious disrepair. Crikey, what's the last one? My mind's gone blank for the last one. But it'll probably come to me. But these are a set of standards by which all social housing providers require to comply. Now, free from serious disrepair would encompass the windows and doors and roofs and render. Modern facilities and services encompasses the kitchens and the bathrooms. The energy efficient would be energy efficient heating systems from a central point. And healthy, safe and secure, that was the last one. And that entails your electrical circuits, your rewiring within the house, door entry systems, well-maintained rear back courts with the washing lines and the boundary fencing and the like, and that the locks in the entrance doors, not the door entries, the entrance doors to houses, to homes, are functioning. So these are a broad set of criterion, and what you do, you need to establish what is the condition of your stock. So you undertake stock condition surveys, and that helps to inform the future planning, because in these stock condition surveys what it will do is it will determine what is the anticipated year of failure of a particular component. It might be a kitchen, it might be a bathroom. Now, these surveys are undertaken, and are undertaken for Eastern Bartonshire through consultancy, which is tendered for in the open market. And these companies who undertake this, companies, their staff who undertake it are all chartered surveyors. And this information comes back, and there is an extrapolation of information taken. So what you've got is you've got clone property. So in any survey you may say, for example, you surveyed, 350 houses. Your data would then increase through extrapolation and cloning, and that then goes into a planning tool. So if we were looking to see what is going to fail and we need to budget for in 2022, we would draw that information out of the failures in 2022. That's the projected failure. And as we go through the planning process and then delivery on site, this is a type of information on our progress that gets fed back to the Scottish Government on our annual returns. And that's how it all works.
I think Mr Farrell asked you if it was retrospective. Mr Farrell, did you mean that the SHQS implementation would be implemented on older properties, or was it only for new properties? What did you mean by retrospective?
Indeed, ma'am. I'm not a great fan of an analogy, but we have a requirement to have seatbelts fitted to cars. That, I believe, came in about 1976, there or thereabouts. There's no requirement to go back to older cars and fit seatbelts to those. So I wondered whether the desire of the council to meet these standards by a certain date, whether that was a best practice desire or whether there was a requirement to do so by regulatory bodies.
Can you give us a view for the deadlines that have been imposed on you for bringing your stock up to these standards by government, or whatever?
The deadline for complying with the Scottish Housing Quality Standard was 2015. And when I was describing to you the process for stock condition, that stock condition should raise out and bring out anything that, for example, should be done, and any failures that should be done before, for example, 2006.
Thank you.
In terms of going back, you're actually catching them.
So it explicitly is regulatory standards that are to be applied to pre-existing stock, not standards to be introduced to new builds. Is that correct?
New builds will meet all current building regulations. They will also meet the Scottish Housing Quality Standard, and they will have to meet the Energy Efficiency Standard for social housing.
So I'm not trying to labour the point, but just to be very, very clear, is there a regulatory obligation on the council to implement these standards in a building constructed in 1968, 1972, whenever Block 2 was constructed?
All property that we own as a social landlord, whether it be built in 1929, 1935, every property requires to meet the Scottish Housing Quality Standard.
Thank you, sir. Those same standards, is there any legal obligation for private homeowners to meet these standards?
I recall touching on this earlier this morning, and I was discussing with Mr Ferguson, where I am aware that homeowners who sublet are now expected to, and I think there's a drive to have them provide accommodation that they're subletting to meet especially East standards. But I would be totally wrong to say I know all about that.
Thank you, sir. I think you've told us, and I can't remember, so I'll ask again if I may. When were you last in Block 2 at Nithsdale Crescent?
Block 2, I wasn't in. I was at Block 3, which is Drybrow Road.
You've never been in Block 2?
I haven't been in Block 2 for a long time.
Approximately years, decades?
I honestly couldn't say. I mean, it's not decades.
Do you remember whether you were in and about it around about 2005?
I was in about 2005 because I was over there with property maintenance, who were the principal contractor, and I had discussions with A.J. Balfour, who were the structural engineers, because it was A.J. Balfour and company who required to undertake the structural calculations and the design and the pitch for the roof. So, yeah, I was aware about that time, but it's not a situation where I'm over there in that area, say, like, for example, once a month. Because if I've got contracts, for example, I've been spending a lot of time in the Twecker area, where we've got a lot of heaps work and external render work. So it's not as if I'm over in that particular area of the flats regularly.
Thank you. You are familiar from maybe access to driver, or certainly from viewing the plans of the buildings, roughly what the layout and configuration of the building is that right?
If I were to, I thought this one might be asked, if I was to stand there and look at those, imagine block 1 was still standing. They all look the same, but I would not say, yeah, they're all the same. I would want to see a set of plans first. With the
that's not where I'm coming from, sir. I'm just generally, if we take it as read that they're the same, I think they're similar enough to be considered that way. You're familiar with a typical maisonette in any of the blocks?
Yeah.
And we spoke to the construction, the standard construction, and what we have there: good solid brick walls, nice concrete floors, a leaking roof. If the only problem that I understand has been identified in the structural report, which is ingress at the roof, if that were to be fixed, if that was your home, sir, how would you feel about it being knocked down?
I'm going to disallow that question, Mr. Farrell. You know, it's a bit like...
May I try a tailored version of it?
Don't think so. I mean, I think the answer is obvious to anybody at all. So I can just imagine what Mr. Miller's answer might be, and I don't think I need to hear it.
Thank you, ma'am. Mr. Miller, sir, I'd like to thank you. It's been a truly informative session, and thank you very much. I have nothing more.
Thank you.
Right, I don't think I've got much, Mr. But bear with me for a moment till I remind myself what I was wanting to ask you about. Yeah, these particular blocks in the area of local government that you've served over these years, are they unusual? Or are they typical of any particular house type? Do you know of any others?
I would say over my time, I've seen similar house types when I was employed by Renfrew District Council.
Similar house types?
In the Renfrew area, yep. I have also seen similar types in Glasgow. And the first time I ever came across them here in Eastern Bartonshire was when the two councils came together to form Eastern Bartonshire.
Now, given that there's a lot of experience of lots and lots of house types, is there anything particularly notorious about these house types? Or is it just the flat roof that everyone hates, or is there anything else wrong with them?
Over my experience in dealing with homeowners, councillors, senior management, technically qualified people, I've never heard of anything that's particular to it, but the one thing that always crops up is the issue of flat roofs, because they're just not something that a lot of professional technical people would even consider.
my questions have actually been answered in the course of your questions. Yeah, when you undertake a modernisation project, as you've explained, so I'm talking about more recently, what's your own, are you responsible for approaching owner-occupiers in the scheme? Is that part of your remit in moving a implementation forward?
If it's okay, I'll give an example. We, as an authority, have been relatively successful in attracting Scottish Government funding for HEEPS, the Home Energy Efficiency Programme for Scotland. And that particular programme will provide financial support to homeowners who reside in non-traditional buildings. Now, the whole principle of the thing is to reduce heat loss, and non-traditional buildings are notorious for that. And there are various types of non-trads, a lot of them. And we attract that information, and then what we have to do is, once we've got that, when we know what area we're going to plan to go, we organise public participation meetings.
So among them, so you're talking about situations where there's a number of non-traditional house types, like
Yes.
Doran houses, that sort of thing.
Yeah.
And these houses would quite often be owned by their occupants. So you've been successful in collecting grant funding, which is specifically to assist with the improvement of that type of house, irrespective of who's in it. Yeah. So, and that's the kind of work with homeowners, engagement with homeowners you're familiar with.
Yes, it's important. It's one of the main parts of the role that I fulfil, and that is to have that engagement with homeowners, so that the homeowners can understand the level of grant funding that's available to them to assist in becoming a part of that overall project. Now, that project would see external wall insulation as a principal measure being applied to the external fabric.
Okay, now, I mean, I do really hate to cut you off on that, but what I wanted to ask about was the process of persuading homeowners to acknowledge that there's a repair necessary and that the council can help them with implementing that. Now, you mentioned that the typical kind of conversation you might have in some blocks would be, I can get that done cheaper, or my cousin's a roofer. Now, but that's, if we take if we take a kind of slightly deeper look at the history of this, there has over the past few decades been various schemes promoted by government whereby grant funding is available through councils for plain and simple rehabilitation of housing under the Housing Act. Have you done any of that kind of work in past years?
No.
Right. Right, thanks. I don't think I've got any further questions for you, Ms Miller. Thank you very much.
Thank you, ma'am.
Re-examination, Ms Hamilton?
Yes, ma'am, and I equally don't have much for Mr Miller. Just a couple of questions. Mr Miller, in answer to a question from the reporter yesterday, Mr Farrell stated that if the refurbishment option was back on the table, he would like to play some part in validating the costs for the scheme. Now, I know that you've spoken a bit today just about the process and generally how these things go, and you've given your evidence of some of the difficulties that can be experienced. Is Mr Farrell's desire to become involved in that cost validation process, is that realistic, given what you know?
Without sounding cheeky, I wouldn't see that that's would be of any benefit, and I don't think it's correct either. If there were to be a refurbishment project, because of the nature of it, and once you know we decided the scope of it, it would be very reasonable to expect the local authority to create a project team. Now, that project team would consist of architects, architectural technicians, clerk of works, chartered surveyors, and the like. We would not put something like that direct in-house. Therefore, it would go to the marketplace in terms of best value. It would be subject to competitive tendering, and the tender returns would be scrutinised from top to bottom by professionals, and then a report would come back to the appropriate parties within the council, and that is when we would see those prices and what have you. I think that it would not, and once again, please accept my apologies if I'm sounding cheeky, it doesn't mean to be that way. I don't think it would be appropriate for Mr Farrell to become involved.
Mr Miller, in your experience of capital works, where there has been an options appraisal, so the council considering various options which are available to it in order to determine which solution it wants to move forward with, once the council has decided upon a preferred solution, would the council subsequently work up detailed costings for one of the rejected options?
I don't think I've ever heard of that before.
So I think in evidence earlier today you referred to some of the costings which are in front of this inquiry as being, if I can use quotes, rough. You said these are roughed up or rough costings which were within the document EDC 131. Is it normal for costings to be, shall we say, rough at the stage of going through a feasibility appraisal?
My experience has shown that when considerations have been given to certain projects and they're out there in the field of consultancy, one of the first things you'll get back is indicative costs, roughed up costs. That simply gives a flavour to the local authority of what you may be looking at. Now, I've never been involved in option appraisal to a point where I'm in the decision-making process, so I wouldn't want to comment on that. But certainly, the council would take into consideration what am I getting for my money. And you will always, if professional consultancies are looking at a block of flats, and they know the council has certain ideas which they want to see fulfilled and bring the place up to a standard, one thing you would get at the outset is indicative costs. Now, we have a project which is similar to the, in terms of there's a project going to hopefully happen, and we've got indicative costs. These costs can only ever be treated as indicative because it's an open market and a tender process. Now, indicative costs would enable you to consider what you would budget for in future, because they are just that, they're indicative. Whether the council would use that to inform themselves of a decision which option they wanted to go, I wouldn't like to comment on that.
Thank you.
Evidence. Now, I did say that if anything new came up, in Mr. Miller's evidence, and you really, really wanted to and could convince me that it was necessary, I might allow the objectors to give additional evidence on the point. I have to say nothing new occurs to me. Anybody get anything else they want to say by way of their own evidence? Good answers. Good answers. I would definitely let you, but I really don't think anything's arisen from Mr. Miller's evidence that requires further evidence from you based on what your statement and of case contain. Right. Okay. Well, that's good. So that's all the evidence over then. The next matters to consider are ones of programming for the written submissions on the new materials and concluding submissions. So let's start with the written submissions, and sorry if I'm repeating myself, but the first thing that's going to happen is that the Council is going to provide both their new documents with their correct names, and you're going to lodge them. They're Council documents, they're just better in the Council, it's easier for the Council to do it. And they're going to be lodged with the DPA, and then they'll appear on the DPA website. And then Mr. Fergus is going to start the ball rolling by making his written submissions on these two new documents. And I think what I'll do is I'll give you a week, which takes us to the Friday of the 6th of August. But if you can get them in quicker, that would be handy, but you've got until the 6th of August. Is that all right?
Yeah, I'll do my best, man. Thanks.
Yeah, that's great. And then after these are in, I would give the Council a week to answer them. So that would take us, I think, to Friday the 13th. I think that's right. Is that right? Yes, that's right. Now, concluding submissions, as I've said before, and I really am quite keen on this, I like the concluding submissions to happen in two sets of simultaneous exchanges, because otherwise you get this endless chain of he said, she said. Now, in normal circumstances, I would have liked to have the concluding submissions in on the Friday, the 13th of August, but as I just, what do you want to do? Do you want to have the first exchange on the 13th, or would you like another week for that? It just seems a bit congested, really, doesn't it, in the reality of things. So, so we'll say that the first exchange of concluding submissions will be on the 20th, Friday the 20th of August.
A point of clarification. When you say on a date, do you have a time on that date? Are we talking before that date, not later than that date, or before that date expires?
Well, of course, you can send them in electronically. If I set a deadline, it would be for 5 o'clock on the day in question, which is the sort of change, more or less, close of business day. So that's actually 3 weeks after the end of the inquiry, which is, quite a lot of time. But after concluding submissions are in on the 20th, I would. The second iteration of that, which would be comments on other people's concluding submissions, I want them in a further week beyond that, so that would take us to the 27th of August. I'll be writing all this out. There'll be a letter from my office making this absolutely clear. So that's 4 weeks after the end of the inquiry, which admittedly is a bit longer than I would really have liked, but here we go. And because it's a bit longer, that's it, in effect, that's a month. I'll be very kind of strict about people being late. Yes, Mrs. Ferguson.
Ma'am, I'm not absolutely certain what a concluding submission is.
Well, in my usual extremely helpful way, I did actually tell you in my letter of the 7th of July.
I've read through all that previously, but I don't know what I'm supposed to
not do. Well,
yes.
It's your final statement, Mrs. Ferguson. It's not new stuff. It's your last opportunity to say what you want to say in the light of the evidence that's being heard. See what I mean? It's the kind of bookend. Statement of case is where you start. That's the case you're going to build. And you hear the evidence, you present your own evidence, and you hear the evidence from the other people. And this is your opportunity to comment on the case in the light of all the evidence. So it's basically that. Importantly, the other thing it does is it gives people who want to do such a thing the opportunity to make any points of law that they feel they wish to make. It's the law, it's the submissions are arguments in law. And the concluding submission is the time when these are made.
Thank you.
If you should feel the need. Obviously, I know enough law to help me to scope the inquiry, but my role is not to give ministers legal advice. I will not be giving ministers legal advice. My report will include the legal submissions and my views on how it all works together, but it will be up to ministers to decide what the legal position is and how it should be applied. But the submissions are your version of it, and so you're kind of using me as a conduit to get to ministers with that stuff. Does that answer your question?
Yes, it does. Thank you.
So that's concluding submissions. And I will be beavering away on those parts of my report that I can. I will endeavour that there's as minimum delay caused by reason of the slightly more extended period, which does happen in so many inquiries. Now, the other thing is site visits. As I've said, I do want to have a good look at this building. I've got photographs from Mrs. Ferguson. I've got quite a few photographs from Mr. Ferguson, which helpfully you gave us an inventory, and you also made explicit in that inventory what I was looking at. So that's very helpful. But I would like to look at the building, and we've agreed, Mr. Miller. I think this suggestion has been made that you could be the council's representative on that visit. Is that okay with you? And Mr. Ferguson has been volunteered as the objector's representative. So the question is, can you take care of all the logistics about getting into the building? Can you do all the things that are needed? Could you do that? I'd like to see all the common parts, I want to see all the rooms, even the ones that are normally locked, if I could see into them. I want to have a look at the refuse chute, lucky me. I'd like to get up to the top of the building as much as I can. Now, I have said that I'm content. I don't really want, particularly in current circumstances of infection, I don't really want to go into any of the homes, and indeed 2 of them have got tenants in them, I understand. So I'm not needing to get into them, and Mrs. Ferguson's photographs will let me see the inside of her house. But I would like to get into any empty flats. Could we do that? And if you've seen Dryborough, can you tell me do you know how the actual configuration of the roof space is? Do you know how that works? Mr. Ferguson says there's a small hatch.
Aye, because what you'll find in Dryborough when you enter it.
I don't need to go to Dryborough, but it's block 2 I really want to focus on. Okay. Well, we'll do what we can. I mean, I'm not going to get an awful lot more information just from sticking my head through a hatch. Mm-hmm. So particularly not, as Mrs. Ferguson suggested, I might meet rats at the roof. Bats. Bats, not rats. So I shouldn't. So I don't want to meet rats, but I don't want to disturb the bats. So anyway, a good look at the building, and I want to look outside. Now, timing. Mr. Ferguson, next week, the only day I can't do, we're talking about a sort of 2-hour visit, I think 2-hour slots at the most, maybe even less. Is there any days next week when you're not available?
As far as I'm aware, right now, ma'am, that's not the case. Potentially, that could change, and if that happens, I'll notify the DPA at the earliest notice due to... Yep.
You could keep that date clear.
Yeah, as far as possible, ma'am.
So, but at the moment you've got your diaries reasonably clear.
Yes, ma'am.
Yeah, the only day I couldn't do would be Monday. How about yourself?
Exit property to get access. And
You might have a difficulty. Well, could I ask you through Ms Hamilton to let my office know as soon as possible if there's any times next week that you couldn't accommodate? Then what we'll do is we'll work from that. As your diary is likely to be the busiest next week, we'll see what we can accommodate. But if you would tell us when you're free next week as soon as possible, that would be very helpful. That would be great. Pass it to Ms Hamilton. Ms Hamilton will pass it to the case officer. The other thing that is sort of hanging over this is the question of alternative sites. And I don't know if nobody will remember, but when the issue of alternative sites came up, I decided to defer any decision on whether a notification was necessary to any of the owners of the sites until I'd heard about them. And I have to say, I don't think there's sufficient circumstances for it to be worthwhile or reasonable to contact any of the owners of any of the sites suggested by Mr Ferguson. So I'm not proposing to invite comments from any of these people. The mechanism is really intended to put landowners on notice if there might suddenly be a proposal for the use of their land that they weren't aware of. And I don't think that the evidence I've heard and the suggestion that any of these sites be used for housing takes us to that point. So I'm not going to engage in notification and comments from those proprietors. I think that's everything. Ms Hamilton, do you have anything that needs attended to that comes to mind? Objectors, do you have anything that you wish clarification on before we close the session?
Just one thing, ma'am, on that process of alternative sites, just because I'm not explicitly clear on how it works. One of the documents that the council is going to lodge very kindly, particularly the special council booklet with its appropriate name, references, as we discussed with Ms Gribben, additional sites. So not necessarily as explicitly defined alternative sites, but it's a reasonable conclusion they could be viable alternatives that have actually already been assessed by the council. Given that those sites haven't been put forward but they are discussed there, would that be something where one of those additional sites may also be an alternative site?
Well, I can't prejudge it, Mr Ferguson. I can't prejudge it, but even on the theory that you've proposed there, it seems very unlikely to me that in the context of this inquiry, there would be any different to the situation I've just explained. That is, that there's a site that might suddenly become used for an unexpected reason. So I think it's most unlikely that any site would emerge. Was my feeling at the moment. It's most unlikely that any site would emerge from the new documents, which would lead me to the point at which the paragraph is gauged, which requires me to notify, requires procedures to notify the owners of alternative sites. It just doesn't feel that way to me at the moment. But I'm not prejudging it, but I think it's most unlikely.
Into a new list of alternative sites for the council to consider, having already gone through the process of considering 21 or so.
I don't think Ms Hamilton's very enthusiastic about the idea, Mr Ferguson, but
I concur, ma'am.
I can't say I'm very enthusiastic myself.
However, I would also say on that note, she's incorrect. I'd just like to state explicitly here, the council has identified additional sites for the construction, specifically of social and affordable housing. It says so in the minute of one of their own meetings
Well,
which...
no, Mr Ferguson, I really have kept this debate clearly and carefully within the ambit of the inquiry rules. And I'm quite comfortable that the circumstances that the rules would require me to notify have not been engaged. And I'm saying to you that I think it's very unlikely that any of the sites in there could form the basis of the same sort of engagement.
Okay, thank you, ma'am.
Right, well, thanking everybody for their participation. I'll close the public inquiry now. Thank you.